ನಾವು ಲಾಂಗ್ ಟರ್ಮ್ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಎಲ್ಲ ತಗೊಳಲ್ಲ.
Memo for
My lord, this is a fresh
posting.
matter. Petitioner husband.
Fresh matters will don't have to mention the direction.
Yes, please, ma'am.
the fresh matter for a family court.
It will come.
Primary hearing it has not.
It will come.
I have moved the two memo. Still, it is not.
Your Lordship,
All the matters that are numbered are coming auto listed. So if objections are there, it will not come.
That is the problem, my lord. We are not compliant. They are not giving the file because 45 days is over. That is the reason. If this memo is accepted, my lord, they will give the file for complaints.
Why have you not done for 45 days? Unnecessarily
Some
burdening the
reason.
court with one memo or the other. Take it. Yes.
Pending memo.
Your Lord.
Third memo I have given, my lordship. It is not posted.
Because the problem is all of you are giving the memos. Every day there are 90, 80 matters in the list. It's not possible for the court. So accordingly, all your memos will come. They will list the memos like whenever it is feasible. So you have to wait.
Short date because the minor even for the major son and daughter also the maintenance was
Which year is that?
is 2025, my lordship.
2025 matter when there are so many other matters which are waiting. Your matter has to be heard out of the time. How?
My submission is, my lordship, the major sons and daughters also the maintenance was
We will see. We will
granted
see.
by the family court.
Please give all the memos for listing as per the court's board. The matters will be listed. They can't be listed whenever you want. Yes.
One
Your
respectful,
Lordship,
Next week, my lordship.
We'll see. Give it to her. Yes.
one respectful submission, my lord. We have filed a writ petition challenging the order of the family court, wherein the family court has granted visitation for the father for both the Gauri and Ganesha festivals, my lord, for the entire day. And if this matter is not taken up tomorrow, the petition will only become infructuous. my lord.
If the office objections are complied
It
with,
is
it will
complied,
come.
my lord. May I
Yes,
request
if
for
it is
tomorrow, my
complied
lord?
with, list the matter. Yes.
My lord, MFA matter, my lord. The parents of the deceased have filed the petition. Parents of the old age person have moved
It will come. It will come in the course. Yes.
Case of death, my lord. Tribunal, entire amount deposited in MSCT
Yes,
tribunal.
yes, yes.
Can you return of TCR?
Submission madavaka.
Tomorrow, ma'am.
My lord, this is a pending matter. The trial court has granted 6,000 interim maintenance amount, my lord. With respect to child maintenance, this honorable court has granted interim order. She has to go to the college and she doesn't have.
Which year is that?
24, my lord.
It will come. Give the memo to the court office. Yes.
Page wise adjournment.
may I submit, Your Lordship?
Yes.
Your Lordship, one submission. No, one matter pertaining to this court today, it has been listed before registrar court, my lords, even after furnishing PF, Your Lordship. The problem is, last date was 29th. I filed it on the 29th itself, Your Lordship.
If it is listed before the registrar, go before the registrar. Court will not.
Your Lordship, Your
Yes.
Lordship, even last time also I
Yes,
appeared, Your
all
Lordship.
the-
They said we have to
all the-
submit before
all
the
the-
court.
Yes.
Number 1, page number 2, serial number 3 to 5, page number 3, serial number 6 to 8, page number 4, 9 to 11, page number 5, 12, 13, page number 6, serial number 14 to 17.
Lord, serial number 14, my lord. I pray for 1 week's time, my lordship. I am the fracture counsel. In the connected appeal, I am for the appellant. Second matter.
Representing whom?
Raghu, my lordship. On behalf of Raghu.
Yes, Mr. Shivanagoda.
I am challenging the liability. I am ready.
List these matters. Anybody wants adjournment, a long date will be given.
Please.
List the matters on 26th of September.
Please.
Much. Serial number
At the
17.
request of learned counsel for the
15, please.
claimant. Huh?
Number 17.
Yes,
File has been displaced in my office. Kindly.
this also in the month of November 11th.
Serial number 15, please, madam. And for the appellant,
Page-
others, 15, other side is here only. Seek the week's time in this case.
This is matter on 27th of November. Yes,
Page number 7, serial number 18, page number 8, serial number 19, 20, page number 9, serial number 21 to 24,
22, please, madam. It requires a TCR. Please. They have moved, I informed already by
Appearing
way
for
of message.
respondent, serial number 20.
Informed ಮಾಡಿದ್ದೀನಿ secretary.
ಯಾರಿಗೆ?
K. Prasanna.
I am K. Prasanna.
I need TCR ಬೇಕಿದ್ರಲ್ಲ, please.
First place.
Immediately, even next week ಬಂದ್ರು, I'm ready for disposal.
settlement or
Lordship,
TCR
I filed
really
IA for
required?
withdrawal of the deposited amount.
Will hear,
Liability,
Your
please.
Lordship.
will hear.
Serial number 24, my lordship. I'm appealing for appellant, my lordship. With the
24,
insurance-
I have the respondent, my lord.
So my senior is going to out of town, my lordship, after 12 o'clock. So requesting for 1 week accommodation.
This is matter on 23rd of September. Yes,
page number 10, serial number 25 to 27, list number 2 for page number 1, serial number 3, 4, page number 2, serial number 5 to 10, page
But
number
serial number 8, my lord, on 14/7/2025, this court has made an hand summons to the respondent counsel who is appearing before the trial court, my lord. A serve the copy, my lord. I'll place it before the acclaimant for having served, my lord. Kindly give 1 week time, my lord. As per this court has passed an order on 14/7/2025 to take out the hand summons to the counsel appearing before for the respondents before the trial court.
memo is directed to be filed when?
I'll file it.
No, there must have been an order in that.
30th,
That
Lord.
if the
30th,
memo is not filed by the time
37,
the petition will
no,
be
no, what
dismissed.
happened? The counsel on record, this data marriage was there, that's why he could not be able to contact him within time.
I'll list this matter after a week, whatever has to follow.
And I'll file it to that memo with regard to that serving this
Yes.
copy.
page number 3, serial number 11 to 14, page number 4, serial number 15 to 23, page number 5, serial number 24 to 33,
My lord, serial number.
My lord, serial number 23, my lords. My lords, the matter is settled, my lords. We need time to file joint affidavit, my lords. The respondent is also before the court, my lords.
You were also mentioning about 23.
Plus 25.
She is mentioning, I think, 23 months.
It is submitted to
Yes,
the
my lords.
matter.
Serial number 23, my lords.
Matter is settled and they'll come up with a joint memo. This is matter on 29.
My lords, my matter, my lord, serial number 26, I request only for a week's time. Interim order may kindly be extended. I am for the petition.
For the adjournment,
My lords, I am seeking for the adjournment. My lords, the file was misplaced. My lords,
at the request of non-counsel respondent, list this matter on December 15th.
My lord's 25 serial number.
My lords, I am for the petitioner. I am also ready, my lords.
Both of you ready? No, every day.
My lords, the file was
what will
misplaced. Next
happen?
week,
Again, this matter will be listed on that day. Again, one matter.
next
has
day,
to
my
be
lords, next date, my lords, I'll not seek for adjournment, my lords. This matter had come twice, it didn't reach, my lords. Wait, 20,
Unfortunately, court is also ready.
yes, my lords. See,
Court is also ready. That's the
twice
whole
it
problem.
was like it didn't reach.
And because every time this list is a big list, so many people are giving the memos, we are
I
not
agree.
listing it. And the matters where they are listed, everybody is asking for adjournment.
No, my lords, this I'm not sought for any adjournment.
I'm telling anybody who wants adjournment, they'll have the adjournment either this end of December or next year January. Please think about it and then make a
My lords,
mention.
interim order may kindly be extended 1 week after any date could be given. No
It should
problem.
also be convenient to the court, not only an.
Yes, my lords,
your convenience.
at any
This
convenience.
is matter on September, convenient is in the month of November.
My lords,
This is a
if
matter
I
on
have-
September 1st at the request of non-counsel respondent.
petition.
Interim order may kindly be extended.
Till then.
My lord, serial number 29, my lord.
Same, it applies to you before you.
We have already forwarded the joint affidavit, my lord.
Hmm?
We have already forwarded the joint affidavit up to the petitioner. As soon as we receive it, we'll file it in the counter, madam.
Where is the petitioner?
Petitioner is supposed to be appear through VC.
That's why if the matter comes, he will come, then we can ask him what is happening.
Obliged.
Yes,
Pause list
Serial
number.
Serial number 25.
yes.
My
Yes.
lord, serial number 25 appear for the respondent.
I appear for appellant, my lord. I am ready because accident occurred in 2021.
What accident? This is a repetition.
Oh,
Second
sorry.
list, yes.
Plus list 2, the main matter itself is posted for judgment today.
Then nothing remains for consideration in this.
That's exactly, my lords, or it can be posted after 1 week, whatever
No,
your
no,
lordship.
not necessary. Then counsel appearing for the respondent submits that the matter is posted for judgment today before the
Today.
trial court as this is a matter arising out of an
Arising from-
interlocutory order. No further orders required to be passed in this petition. Accordingly, dismissed as infructuous. Yes.
35, my lord.
Page number,
Yes.
page number 6, serial number 34 to 37.
35 second call, wherein I'm the petitioner, my lord. Either memo of calculation I was directed to furnish. I applied certificate copy of the trial court. So I paid the entire whatever amount I have
Why
paid.
do you require a certified copy of the trial court? You can as well tell the court, this is what you have paid.
But I instructed the client to bring all the details.
No, that doesn't, why should we keep the matter pending like that for such simple reason? Other side is appearing, whether you are paying or not, I'll hear the matter
No,
and dispose of.
other side I'll inform.
Not inform, I'll dispose of this matter.
Because the thing is, we paid extra amount. See, that is, I'll have to give
That
it
will
in
be decided
writing.
by the trial court.
I'll 6 to only one short. This is the first time I.
Problem is, whenever an interim order is there in your favor, you keep on asking.
Actually,
for
that
it.
was not operating. What has happened is the respondent, the petitioner's salary is held up, and they have in spite of payment also.
All the more urgent.
I
for you-
affected in spite of the order also. It
All
was.
the more urgent for you that the matter should be heard. We'll hear the matter.
I do agree, my lord, because I'll have to produce that memo calculation so that it can be easy for disposal.
It's easy for me as it is also.
No, my lord, because I had to produce the document because I have to.
No, you don't
I
have to-
6 only 1 week's time.
Don't have to worry about the court's convenience. Court will take care of it.
1
Please
week's
come.
time. 1 week's time.
There should be a reason for adjournment.
Because without document, my lord, if I can unable to convince this court
We will
because
see whether you can convince it or if it is required.
no, memo of calculation has to be filed. My lord. That's why I'm
We will see.
List number 3,
Yes.
page number 1, serial number 1 to 3, page number 2, 4 to 7, page number 3, serial number 8 to 12.
Just
Serial
call
number,
the-
serial number 9, my lord.
Oh.
I appear for respondent. I seek for two weeks time, my lord. The record counsel, he is suffering from jaundice. He's taking Ayurvedic treatment, my lord. 2 weeks time may be granted.
At the request of non-counsel respondent, list this matter on 27th of November. Interim order, look at it. Yes.
Much.
List number 1, for being spoken to, serial number 1,
Please.
BC Shivanya Gowda.
Interest rate, my lord.
RPFC memo, my lord, the package have been settled before the mediation.
Tomorrow, yes.
My lord, this case is disposed of non-compliance of office objection, my lord. I have filed the restoration of.
No, why should, there is no urgency for that? But whenever that matter comes, it comes. You don't comply with the office objections.
I already complied.
Court has to pass an order. Then for recalling of that order, you will file another application that has to be taken out of turn. You file it whenever the court has time, it will come. And don't take any memos where this applications recall of the dismissal order and all filed. Let them come in their own usual course.
Fresh matter,
Yes.
my lordship, madam.
Not about your matter. Fresh matters will come. There are standard instructions from the Honorable Chief Justice and also from this court that once your office objections are complied with, matter has to be listed immediately. For that, no memos are required. Yes. Yes, where is it? Page number?
The last portion of order, 9% interest was granted, it is reduced to 6%. It is not
Forthcoming.
report.
Paragraph number 10. The claimants are entitled after paragraph number 8. The court had granted compensation. Whose appeal is this?
It is my opinion. Insurance
The
company.
court has granted compensation of an amount of, the court has granted the interest at 9%. And the same is reduced to 6%. And that should come, reduce if any amount is, amount individual forthwith transmitted. Pay the compensation. Here again in paragraph number, here also, the amount shall fetch 6%. The entire amount of, the entire compensation shall fetch an amount of this 6% interest. That's the only thing.
That is
It is submitted that.
much.
The court has in fact reduced the compensation, then it reduced the rate of interest from 9% to 6%. And that is not forthcoming in the order. Accordingly, at paragraph number, after paragraph number 8 and in the next paragraph, it should be incorporated as so and so. Yes, next.
Ordered matter, serial number 2, FS Dabali for appellant Sridhar DS.
Yes, you can argue.
This is my lord, death of 14 years old boy. By relying on my lord, Kishan Gopal's case, my lord, 5,62,555 has been awarded. Only my lord, 80,000 has been awarded towards loss of law and affection, my lord, by following the
Not there.
Parnasati case.
Huh?
By following the Parnasati case, my lord, extra amount of rupees 80,000 has been awarded towards the
You
loss
that
of.
Kishan Gopal?
As per Kishan Gopal case, my lord, 5 lakh, my lord, 4,50,000 plus 50,000
We'll see.
conventional heads.
Meena Devi also there. Hmm. 222 page number. 222 to 231.
Para 18 months it has been
Hmm.
extracted.
Hmm. Justice Maheshwari's judgment. Justice Maheshwari. Give it.
In para 18 of the judgment, murder, type to base 15 of the judgment, it has been extracted. Murder. For relying on the Pranayasati case, murder, 80,000 has been awarded towards loss of law and affection.
There is one more set of judgments. There's one more set. Kajal is also there in that. Kishan Gopal also there. In this judgment also it is discussed in Veena Devi also. Kishan Gopal and others was a Lala 2014 1 SCC 244. If it is not there, please keep that judgment also.
In para 18 of the judgment, it has been extracted.
Kurvan Ansari is also concerned. 70 is there. Yes, Kishan Gopal is yes.
Para 18 of the judgment, it has been extracted.
Yes, yes.
Only rate of interest can be reduced from 9 to 6%.
Open the door. Outside. Notional income at 30,000 into 15 is 4,50,000 and 50,000 under conventional heads towards loss of love and affection. So and so. The said amount will carry interest at 9% per annum.
Instead of 9%, 6%. In Kishan Gopal case, 9% has been awarded.
But you're relying on the such judgment for removing that amount of 60,000, then 9% shall also apply.
Then what 80,000 loss of fraud affection has to be
Huh?
80,000.
That we will remove, but
It can
the
be.
court says it is 9%.
It can be. It can be.
Hmm?
It can.
And in Meena Devi, I think some more amount is granted in addition to that. Three lakhs, the total amount would be rupees 5 lakh.
Medical expenses amount 17,555 has been awarded. It has to
In
be.
this, the enhanced amount shall carry interest at 7%. In the next judgment that is followed, we will grant, we'll let it be 9%. Please come. Agreed with award passed in MVC number 1775/2018 dated 11 November 2019, whereby the tribunal had granted compensation of 5,62,555 at 9% interest. The insurance company is before this court. Land counsel appearing for the insurance company submits that in the light of the law laid down in Kishan Gopal versus Lala, Kishan Gopal and others versus Lala and others, reported in 2014, 1 SCC 244. The notional income is taken at 30,000 and the loss of dependency is awarded at 4,50,000. The loss of dependency is at rupees 3 lakh, 4,50,000, and 50,000 is awarded under the conventional heads towards loss of love and affection. It is submitted that in this case, court under the head of loss of dependency had granted an amount of rupees 4,50,000, but when it comes to the loss of love and affection, an amount of rupees 80,000 is granted towards the transportation of dead body and funeral expenses 15,000. Medical expenses, anyhow, they're entitled.
Yes, that is what I said.
And towards medical expenses 17,555. Altogether, for an amount of rupees 5,62,555 is awarded. Land counsel submits that under the head of towards loss of love and affection, transportation of dead body and funeral expenses. Instead of 95,000, it should have been 50,000. It is submitted that the interest that is granted is at 9%. The same has to be reduced to 6%. Next paragraph. Though the matter was listed on several occasions before the court, there was no representation on behalf of the respondent. The court has given enough opportunity to the counsel to represent the case. In spite of that, he has failed to appear before the court. Hence, the matter is listed today, and the order is passed on the last occasion that by the next date of hearing, even if there is no representation on behalf of the respondent, orders will be passed basing on the material on record. Next paragraph. Having heard the counsel for the petitioner, peruse the material on record. What is the age of the deceased?
14 years now.
The deceased is 14 years. In the light of the judgment of the apex court, in Kishan Gopal's and another, the Kishan Gopal's case before Supra applies to the facts of the case. In that, the Honorable Apex Court has taken the notional income at 30,000 and by applying the multiplier 15 had granted an amount of rupees 4,50,000 under the head of loss of earning and 50,000 under the conventional heads. Altogether, an amount of rupees 5,000 is granted, but however, the interest in the case is granted at 9% per annum. As rightly argued by the land counsel for the insurance company, the claimant is entitled only for the law under the head of loss of dependency 4,50,000. Other conventional heads 50,000, and the medical expenses 17,555. Altogether, claimant is entitled for an amount of rupees 5,17,555. As far as the interest rate is concerned, the apex court in Kurvan Ansari's case has granted 9% interest. Hence, this court is not, when the petitioner, when the appellant is relying on the said judgment, this court cannot take an exception as far as the interest is concerned. Accordingly, the appeal of the insurance company is partly allowed by reducing the compensation from 5,62,555 to 5,17,555. The amount shall carry 9% interest. Take this.
And the amount in deposit.
Amount in deposit shall be forthwith transferred to the, take this. Shall be forthwith transferred to the tribunal. Yes.
Cell number 3.
Yes.
Number 3.
Appear for
Memo for acceptance of paper publication in respect of R3, same accepted. Notice to R3 is held sufficient. Admit TCR is already there.
TCR is a short point is involved. So
Where
it's
is
a compensation.
it? You ready?
It may be have it on
Pass
Saturday.
over?
It may be have it on Saturday.
Saturday?
Yes.
Saturday. This is matter on Saturday. Next 4.
Cell number 4. Cell number 4.
In this matter, I undertake to file wakalat for appellant, my lordship.
What is the issue?
Injury case, my lordship.
That
The
TL is
previous-
not there to drive a motorcycle. He had a license to drive LME, but he is not having.
Court do. What was the order?
Gain recovery has to be passed. That's all.
This is not your appeal.
This is my appeal, man.
One is
Four.
their appeal.
We have also prepared
4.1
appeal.
Second
is
matter,
there.
4.1.
Then we'll dispose of in the afternoon. You can file.
I need to file wakalat
1 week. 1 week time we will grant. Or Saturday.
Saturday. please.
This is matter on Saturday. Mr. So-and-so submits or he has instructions to file wakalat. Yes, 5.
Cell number 5.
Steps, I'm already,
First one down.
I'm take already
Cell
steps
number
on,
five.
sent to
Is
through
submitted.
RPD.
When did you
The
take
lordship.
this step?
And some 9th June.
It is coming latest one.
No such person in that address.
So again, you have to take the petition needful shall be done within a week. Default order. This next.
With your lordships kindly, there is a connected matter filed by the insurance company,
Just
may be
along
called
with so-and-so.
MFA 3704/20.
And
Yes,
give
my
it to the
lords.
court officer. Yes, next.
370.
Cell number 6. Barkude, madam.
I appear for the.
Who is R1?
My lordship, R1 is no more. He died on 21/8/2025. I received information by today morning, my lordship.
It is submitted that the R1 is no more. The particulars will be furnished
Please, my
by
lordship.
the respondent.
I shall
This is
make
matter
application.
after 3 weeks. Next.
Cell number 7. Hearing on interlocutory applications.
Why notice is not or recalling application?
Since I was not keeping well, my lord, I could not represent the matter before the registrar. It was dismissed for non-compliance of office objections.
For 737 days. How can there be? How can you be not well for
I will
737?
not claim any interest.
Not interest. Why? What is this?
By oversight, my lord, I could not follow.
An MFA of 2022, notice is also not ordered till now. Delay to be corrected in affidavit as 737. Have you corrected till now?
No, my lord. Pray for weeks. time.
Pending consideration of IA number 1 of 25. Appellant is permitted to carry out the necessary corrections. If the corrections are carried out, list this matter on Saturday. Or else the IA stands dismissed.
Cell number 8. R. Shashidhara.
873 days delay in filing the appeal.
Claimant.
Claimant appeal.
Lords, Lordship kindly see they have filed affidavit, Lords. In the affidavit, they stated that in the year 2018 itself, they are aware of the judgment, Lords. And 2017 is the award, Lords. 2018, they are aware of it, Lords.
Financial difficulty, liability is fixed on the owner, not taken the compensation.
financial difficulty and my lord,
Because Motor Vehicle Act is a beneficial legislation, that doesn't mean that Section 5 of Limitation Act reasons
I'm
are not
stated
applicable.
clearly why the reasons of the delay. I'm
What are the
stating.
reasons? When you know that
Plus,
the order is passed in
2000
the year 2018, you keep what,
Malas,
700
no,
and
2018 Malas, after Malas, I tried to get the compensation Malas. Since the liability as owner is not deposited the amount Malas.
if he is not deposited, you will file execution. Why will you file appeal?
They try to execution thereafterwards Malas, due to financial difficulty and Malas other difficulties Malas filed appeal after delay Malas.
873 days, how many
873
years?
days. Liability is on the owner Malas.
So,
I may not be entitled for interest on the liability.
but there should be some, I can understand 100, 200 days, 873 days, forever the insurance company will be, or the owner will be looking at when you will file the appeal. There should be that, the whole purpose.
Liberal
of
approach regarding the climate Malas, he lost Malas, the limbs Malas in the accident. And also suffered agony Malas.
I number 1 of 23 is 22 is filed to condone the delay of 873 days. It is stated that in the accident, the claimant has lost the limbs and also due to financial difficulty, he has not filed the appeal in time. Then counsel appearing for the respondent submits that the respondent has filed his objection. Then counsel appearing for the respondent submits that the reasons that are stated, the no reasons are stated to condone the delay. When they are aware of the order in the year 2018, why they have come before the court after the delay of 873 days is not explained properly. It submitted that the IA has to be dismissed. Next for this is an appeal filed with the claimant. It's a case of injury, and in the said accident, it is submitted that he has lost his limbs.
No, femur, my lord. Fracture of femur, my lord. No limb is lost.
Yes, you just only
Injury
said-
to limb.
Femur.
And also Malas stated due to COVID outbreak Malas, outbreak COVID I could not able to file in the affidavit.
Just before you said that he lost his limbs.
No, so last is due to injury Malas is
You said you
sustained
lost
injury,
his limbs.
pain and agony Malas.
That is the
No, it's
reason.
case of
That is the
injury.
reason I started.
Last is limbs means my submission is Malas due to injury Malas is sustained. Last is difficulty,
I think
parent suffering.
English for you and for everyone is one and the same.
Same. I'm sorry for that. And also due to COVID outbreak Malas.
He sustained that limb thing. It is submitted that he has suffered injury. Considering the fact that it's a case of injury and also the financial difficulties that are stated, balancing the interest of both the parties, this court, the IA number 1022 is allowed by condoning the delay of 873 days on the condition that they will not be entitled for the interest for the delayed period. Admit call for the TCR. Yes, next.
Cell number 9.
Yes.
Cell number 9, A. Ravi Shankar.
I am for the respondent.
Appear for the appellant.
What is this IA number 2 of 25?
It is for withdrawal.
Withdrawal of amount.
I am filing my objections to. May I be permitted to file here?
We'll hear this matter on Friday. This is matter on Friday.
It may be taken up for final.
That's what.
Yes.
Instead of hearing the IA, we'll hear the matter. Yes.
Please, ma'am.
29th. Yes, next.
Cell number 10. Cell number 10, Prakash MH.
I number 1 of 23 is filed to condone the delay of 52 days.
For the
in
appellant,
filing.
Your Lordship.
Delay is condoned.
Lordship, I filed a memo to
Vijay Kumar.
return back the LCR to the lower court because they have deposited the amount in tribunal. They need to.
Which is at IA?
I filed a memo, Your Lordship. On,
Memo is filed.
Yes, Your Lordship.
To return the TCR as
No memo is there, ma'am.
On 26/2025, I have filed.
the appellant, the claimant wants to withdraw the memo is not there.
Lordship, I have an office copy.
There is no reference for the same of TCR.
TCR is also not here.
Please, Your Lordship, because we had an instruction stating that the TCR is here, that is the reason.
Huh? It is submitted that the respondent insurance company has deposited the amount and they want to withdraw the same, hence the TCR may be sent back. The registry is directed to send back the TCR and immediately after the amount is withdrawn, it should be sent back to the High Court. Yes.
Obliged, Your
11. Serial number 11.
It's delay of 52 days.
I am for the respondent in this case, my lord. I am filing the objections to the delay application in this case. Usually, respondent has been placed the ex parte before the tribunal, my lord. They have not made the RC owner as a party, my lord.
Who are you?
I am for the respondent Tamil Nadu State Transport Corporation, my lord. In the trial court, my lord, they have made the managing director SCTC bus depot Shanti Nagar, Bangalore, my lord. Whereas in my RC book, my lord, I furnished the RC book.
May I submit, my lord? He filed the miscellaneous petition to set aside the judgment and award passed by the tribunal. That was dismissed. He has not challenged that miscellaneous petition order was made on 9/8/2020-24.
Not questioned.
Therefore,
My lord, we will question that, my lord. Even in the miscellaneous petition also, the claimant counsel has filed the memo to
I'm asking,
follow the miscellaneous
have you
petition, my
questioned
lord.
that order or not?
I have to challenge that order, my lord. For that
So
reason,
without challenging that order, whatever ground, all those grounds you cannot take now.
my lord, in this case, claimant advocate himself has filed the application to allow the miscellaneous petition, my lord. Even on wrong assumption, the trial court has dismissed that miscellaneous petition.
no
my
wrong
lord.
assumption, only to
Memo is there, my lord. Memo
Then you-
avoid the delay, my
When-
lord.
Come up with your appeal also, we'll see. This is matter after 4 weeks. Yes, next. 12.
For the appellant.
I refer.
The first
One and
appeal
two.
is with regard to liability, my lord, and the second appeal is with regard to enhancement. The liability, my lord, is cast on the owner on the ground that, my lord, he did not have a license for a transport vehicle, but he had a license for a light motor vehicle.
Then the
Yes,
judgment
it
will
is
apply.
covered, it is covered. It is less than 2,500 is the gross vehicle weight. So therefore, my lord, insurance company is liable. Mukund Devgan, my lord, and is followed by, yes, that is a short point, my lord, that is involved.
In
First matter, my lord, liability.
second one,
Second one is for
I appear for
enhancement.
the
filed by-
appellant, it's for enhancement. Actually, may,
of death or injury.
injury. my
Injury,
lord.
my lord.
So let's see.
I am appealing for the R2.
First of all, this in 12.1, 12, IA number 1 of 23, this is by the insurance company.
They are not contested before the trial
No,
court.
MFA 2, first, 1 minute. MFA 2116 of 23 is filed by whom?
Filed by the owner, my lord. Owner of the vehicle.
You are representing him.
Yes, my lord.
IA number 1 of 23 is filed to condone the delay of 107 days in filing. The delay is, for the reason stated, the delay is condoned. Then 12.1 is by the claimant. IA 1 of 23 is filed to condone the delay of 33 days, same for the reason stated, the delay is condoned. Now, let's look at, let's dispose of, first is MFA 2116 of 2023.
Yes.
Where is that finding?
Lord, finding with regard to liability, Lord, para 28, page 37. Lord, kindly come to page 38, para 31, my lord. In the present case, accident occurred on 5/1/2019. The goods mini lorry is a transport vehicle. The driving license was valid for transport vehicle from 7/8/13 to 5/5/20. For LMV transport gap period from 4/8/16 to 10/1/2019, there is no endorsement. On 5/1/19, the RW1 did not have DL for transport vehicle. For exhibit R3 is a policy. For the breach of policy, insurance company or respondent number 2 cannot be held liable to pay and recover. Pay and recover ratio is a
Yes.
then para 32 Mukund Devgan's case is cited, but the tribunal holds it is before a larger bench, so therefore, my lord, Mukund Devgan is not followed. Now, my lord, the law is settled. Mukund Devgan and my lord.
What do you say?
Lordship. He has not participated before the lower court, Your Lordship. And he has not produced the driving license, and we only produced the driving license. He has not
No,
participated.
basing on
Correct.
Basing on the discussion at 31, 32, that is sufficient for this court to say, in the light of the law laid on Mukul Devgan, insurance company is liable.
Because see, as per the.
The court has appreciated, but anyhow, there's a matter is pending before the larger bench, that law was not applied.
Yes.
So we don't have to go into any other things. Please come. MFA 2116 of 2023 is filed with
Because of at least interest, because he has not participated before the court.
I have filed written statement.
It is
It is
statement,
on
but
record.
we have not produced the documents. I only
Lord.
produced the documents. He never, this one only filed the statement, kept quiet. We have produced the documents.
MFA 2116 of 2023.
That's why the court
Why you
fixed
have
the
not-
document.
No,
Why we
in the
can
filing
produce the
it-
document before the
Filing
court.
also there is delay 107 days.
My lord, earlier an appeal was filed. My
Oh,
lord,
that 107 days on condition that for the set period,
Yes,
the owner is liable to pay the interest. Next, the
earlier, my lord, it was entrusted to an advocate. Appeal was filed. It was filed in the name of the claimant by mistake. That was withdrawn and, my lord, the proper appeal was filed. I have produced that order also.
Their contention, their.
I 107 days interest, my lord. Yes.
Balanced will be balanced.
Very well.
So the win-win situation for both.
Yes.
The agreed with orders passed in MVC number 1300/2019 dated 26 August 2022, whereby the liability is fixed on the owner of the vehicle. The owner is before this court. Land counsel appearing for the owner submits that though the driver is having a license to drive the LMV, is also authorized to drive transport vehicle of LMV class, and they have also relied on the judgment of the Honorable Apex Court in Mukund Devgan's case. The same was not considered by the court on the ground that the same as pending consideration before the division bench, before the larger bench. It is submitted that now now the law is settled, and as the driving license for non-transport vehicle is varied from 7/8/2013 to 5/5/2020 for LMB transport from 4/8/2016 to 10/1/2019. And in the light of the law laid on in Mukund Devgan's case, still the insurance company is liable. Land counsel appearing for the respondent insurance company do not dispute the fact that the judgment of the Apex Court in Mukund Devgan's applies to the facts of the case. However, it is submitted that the owner has not contested. He has come before this court with a delay. This court has already directed that for the delayed period, the owner has to pay the interest on the amount in the amount. Hence, in the appeal filed by the owner of the vehicle is allowed, and it's the amount of compensation the insurance company is liable to pay, and the interest for the period of in the conditions so and so days the owner of the vehicle is liable to pay.
At least 9% to 6% you can reduce. Owner appeal, you can. 9% is awarded.
The amount of interest is
that is has to be
reduced from 9% to 6%. Yes, next.
That enhancement is there.
One another matter.
Next is no, appeal is allowed. Yes,
12.1, my lord. The petitioner has sustained one fracture injury. One fracture injury, my lord.
Pain and suffering, one fracture, 40,000.
Page number 21, your last.
Yes, I'm looking at. Then medical expenses as it is.
It's a
Yes,
19, sufficiently awarded, your last.
That is regarding pain and agony fracture.
Another 10,000.
Yes, ma'am. And the conventional act also.
1 minute. Please look at it. We'll go one by one.
Yes, ma'am.
Then future medical expenses.
60,000 is out.
I think there cannot be any enhancement than this.
Yes, ma'am.
60,000. How many days he was in hospital?
Nearly 25 days, my lord.
Another 5,000.
Yes.
Then income was considered how much? What was which year is the accident?
It is of the year 2019, my lord.
19 is 14,000.
That's minor.
Petition is a minor.
Petition is minor.
Oh, he's a minor.
Minor, that's why last.
Income of the parents is that is
Because
mentioned
it
like
cannot be considered. Permanent disability is already granted 3 lakhs.
loss of
And
income.
other things already granted everything because cannot be enhanced. It is retained and your lordship because owner appeal he has come for the after that. he has
Because Master
filed the-
Mallikarjun
Yes.
case will apply.
Malik applied, it is reduced.
Yes,
If it is applied, it will be reduced.
Because there is no award against me, that's why I have not challenged. Otherwise, we would have challenged.
Yes.
Till today, we can have
We'll
a
dismiss
chance
it.
to
We'll dismiss
file a
that.
cross appeal.
That's what I was thinking, that is in
Ah,
case of
I
a,
said that your lordship minor already, but your lordship calculated, that's why.
yes, the agreed with award passed in MBC number 1300 of 2019 dated 26 August 2022. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed stating that seeking compensation of an amount of 12 lakhs for the injuries sustained by the minor who was aged 14 years.
5 years.
5 years.
As on the date of the accident. The court had granted 6,99,660 under the following heads.
Which
Extract the
is
table.
rounded up to 7 lakhs, my lord.
And rounded off to 7 lakhs. Learned counsel appearing for the appellant submits that the court has not granted the just and reasonable compensation. Learned counsel appearing for the insurance company as well as the owner submits that in the light of the law laid down by the Honorable Apex Court in Master Mallikarjun's case, the amount already that is granted is on the higher side and the claimant is not entitled for compensation for any enhancement. Next para. Having heard the counsels on either side, there is a material non record. This is a case where a minor got injured who is aged about 5 years. In that case, the law laid down by the Apex Court in Master Mallikarjun's case applies. And what are all the headings under which that is given is already on the higher side. Hence, and as there is no appeal by the insurance company, this court is not going into that aspect. And at the
Also,
same
your
time,
lordship can say, because liability fixed on the owner, that's why that is also a thing.
then don't write anything about insurance company. So, this court is not inclined to enhance amount. There are no grounds to interfere with the, there are no grounds for enhancement of the compensation. Accordingly, appeal is dismissed.
Lord, 6% interest, your lordship, from the date of the petition till 6%.
It's already clarified in the other order, why it should be in this.
My lord, in the first matter, I have deposited 50%.
Amount in deposit
That
shall
may
be
be
forthwith
refunded.
transferred to the court. And or here it is deposited.
Before the tribunal.
Amount in deposit, the owner is at liberty to withdraw.
Withdraw. Oh.
Cell number
Much obliged.
13, Sriram Adiga.
Appellants in this case.
What is the
Filing
sub-service of notice?
My lord, I am filing a memo withdrawing the paper publication IA and the deletion of the parties, my lord. Because, my lord, the same is
Memo
not.
is filed.
Yes, my lord.
IA number 1 of 25 is filed, seeking substitute service of notice to R2. Then IA number 2 of 25 is filed for deletion of R4 and R5 and also to dismiss IA number 1 of 25.
Please.
Memo is taken on record and the notice to.
My lord, one more memo I am giving, my lord. Respond number 2 and 4 may be dispensed, my lord, because there is no
What is
liability.
deletion of R4 and R5? I am not able to understand.
Yes, my lord, there is a problem between the code copy and office copy. This is a NOC file, my lord. This is the reason I filed respond number 4 and 5 is not forthcoming with the code copy. That is the reason, my lord. It's a miscalculation. I'm withdrawing the same, my lord.
Give that. Show the award. As per the award, there
Yes,
are
ma'am.
4 respondents.
Yes, my lord. Yes.
And now you say to delete respondent 4 and 5.
Yes, my lord. But in the office copy, there is some addition of parties. That is the reason. By mistakenly, they have entered it, my lord. That is why I am also confused, my lord. That's the reason I filed it and now,
Want 4 to be deleted. Why 4 to be deleted?
now I am not really, I am withdrawing the same, my lord.
Deletion of parties, who are they? Which parties? You say 4 and 5.
Yes, my lord, but
Why 4 should be deleted?
no, my lord, 4 is not deleted, my lord, only because, my lord, in office copy 4 and 5, some different persons are entered. On the time of filing the appeal, they entered some different names.
We'll not look into all these IAs. The several IAs are filed with lot of confusion.
No, I am,
That the petitioner, the appellant has shown some other persons as parties to this petition.
the same.
The petition shall file an application for amendment of the cause title, and then basing on that, we will amend it.
No, my lord, cost title is correct, my lord. As per the court copy and award, cost title is correct. My office copy is, there is a mistake in office copy.
Who office copy means what? I don't understand.
No, which file I am maintaining for my,
So if something is wrong with your office copy, what the court should do?
yes, my lord. So that is
Your
the-
office copy court will correct from here.
No.
Then-
That is the reason, my lord, I am withdrawing all my applications, my lord. May be taken on record, my lord. So 23.
Then I will not record anything. If anything, it is at the risk of you. I have 1, 2, a memo is filed seeking to, it is submitted that the IAS may be dismissed. I number 1 of 25, I number 2 of 25 are dismissed.
Yes, please. Memo is also maybe withdrawn, my lord. And also, my lord, I am filing one more memo seeking dispensation, my lord, against the notice to respond number 2 and 4. Because in the award, there is no liability against the 2 and 4, my lord.
A memo is filed
Please.
seeking to seeking dispensation of notice to R2 and R4 as no liability is fixed on them. Memo is taken on record.
Yes,
And
ma'am.
same is dispensed. How casually you are filing the memos and prosecuting the matter.
My
Very
apologies, my lord.
unfortunate.
My apologies, my lord.
Very unfortunate.
25 is filed for special publication in respect of art. That there also the addition.
All the IAs, all pending IAs are dismissed.
Yes, my lord. And one limitation I is there, my lord, that may be kept pending, my lord. On the time of filing the appeal, I filed limitation that may be kept open, my lord. Rest all IAs may be dismissed as withdrawn, my lord.
Why should this exercise the court should do? I'll impose the 10,000 costs
No,
to be
no,
paid
no.
to the Advocates Association.
My apologies, my lord.
What is this?
I'm intentionally not doing, my lord, because it's a NOC file, my lord. That is the reason, my lord. I have to go through the pending and then only I got to know
Get
this,
all
the
those
parties.
IAs and then place before me. Yes, next.
Yes.
Please.
Serial number for admission matter, serial number 14. 14 urgent, 15 urgent, serial number 16.
Yes.
16.
Where is Mr. Sabur?
Dabali.
Passover?
Because records may be necessary, but in this.
Records are necessary.
necessary.
Admit post of final hearing, call for the TCR. Yes, next final hearing.
For final hearing matter, serial number 17 urgent, serial number 18.
Yes.
18. R. Shashidhara.
Kindly it may be taken up day after members.
Huh?
Kindly it may be taken up because it's on negligence aspect. All the depositions are in Kannada, my lords. I'm placing my reliance, my appeal is on the ground. It is an head-on collision between two motorcycles. The motorcycle on which the claimants for proceedings had 2 pillion riders, and he has gone to the extreme wrong side of the road and has collided with another motorcycle which you insured with the company. We have examined the IO. IO says that the accident has taken place in the wrong side of the road. They have come to the wrong side and they have hit the motorcycle, my lords.
You can read.
My lords?
You can read the evidence and you can tell the court why the further transfer.
Yes. It may be taken up on Saturday. I would.
See, because all these
Yes,
matters are listed, some other matters are not listed.
Yes, my lords.
No, the
I'll
court
go
is
ahead with
really
the
not
matter.
comfortable
I'll
with
go ahead
this
with the matter,
adjournment.
my lords. I'll go ahead with the matter.
With this matter on 25th of September. Yes, next. Call the other matter. September.
Serial number 19.
You are on what ground?
Implication of the appeal. I'm got translated. Just a minute.
This case of a hit and run case, and the brother of the injured, the deceased, has filed an
It's a case of 163 or 166?
hit and run case,
163 or 66?
166.
Hmm.
And the brother of the deceased had given a complaint, which annex exhibit P2, translated copy of again, just now again. I have printed it. I state that my parents have two sons. Your Lordship got it.
How they come to know that this vehicle is involved?
Subsequently, a restatement was taken.
No. When is the accident?
Accident is dated
15 to 19.
15 to 19 at about 10:30 p.m.
15 to
19 at
2009.
10:30 p.m.
Hmm.
And accident, the complaint is given on 16 to
How the injured or is it injured or
he
disabled?
was walking on the road, and it's the claim that he was hit by the an unknown vehicle, and he succumbed to the injuries. Subsequently, a restatement
What
was
is
given.
that place? Where is the place? Is it
Down here, it's a place called
inside it's a city or
Mariam,
outside outskirts?
outside the outskirts.
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 Hmm.
They may read exhibit P2 Miller, translated copy. From the third line, I state that my parents have two sons. Our elder brother Ambarish Naik has polio and is disabled due to this. He earns a living by begging at the bus stand and other places every day and comes home at night. He doesn't listen to anyone. Every morning, he would leave our house in the Mariamman Halli and go to other places and then return home at night. Since he was disabled, we left him alone. On 15 to 2019 at about 10:30 p.m., the police from Mariamman Halli police station called us and informed that your brother Ambarish Naik met with an accident near Nandibandi village near the bridge SH State Highway number 25 road. The driver of some vehicle was driving his vehicle in high speed and reckless manner and hit Ambarish Naika, who was walking on the side of the road, causing the accident. The driver of the vehicle did not stop and drove away. Due to this accident, Ambarish Naika suffered heavy injuries. He had suffered severe injuries to
Yes, I've
ear,
seen this. I've seen
and
this.
he succumbed. And
So as on the day when the complaint is given, it is an unknown vehicle.
unknown vehicle.
Then-
Subsequently, a restatement was given by the complainant. Your Lordship get it exhibit P5. Next document is
P4, next is P4.
spot merger. Next document, Your Lordship.
It is on which date? On the same day.
It is on 16/2, next day.
This is, first one is?
15/2.
16 First one is also 16
This one is also 16.
15/2.
Date of
On
venture.
15/2, complaint is 16/2. But the accident is the date of accident. Subsequently, on the very same day, on 16/2/19, he gives a further statement stating that our elder brother Ambarish Naika was hit by some driver of a vehicle near Nandibandi village. The driver of the vehicle was driving his vehicle at a high speed and recklessly and caused the accident to our elder brother Ambarish Naika, who was walking on the road, and
Was he examined?
he was not examined.
He was not examined.
He's not examined.
16/2, my lord. This
First, when
exhibit
you are given the first complaint, you do not know. Immediately you give this complaint. You must have known it for some, whatever, how you have known about that involvement of the
police
vehicle.
only informed me, my lord, in the complaint, it is stated that, my lord, complainant, police
No,
called
no.
him
No,
and
no.
informed.
You read it. You read the
Please,
exhibit.
I
P5.
read it in Kannada, my lord. ದಿನಾಂಕ 5/15/2019 ರಾತ್ರಿ 10:30 ಗಂಟೆ ಸುಮಾರಿಗೆ ಮರಿಯಮ್ಮನಹಳ್ಳಿ ಪೊಲೀಸ್ ಠಾಣೆಯಿಂದ ಪೊಲೀಸರು ನನಗೆ ಫೋನ್ ಮಾಡಿ ನಿಮ್ಮ ಅಣ್ಣ ಅಂಬರೀಶ್ ನಾಯ್ಕನಿಗೆ ನಂದಿಗುಡಿ ಗ್ರಾಮದ ಸೇತುವೆ ಹತ್ತಿರ ಯಾವುದೋ ಒಂದು ವಾಹನ ಚಾಲಕನು ತನ್ನ ವಾಹನವನ್ನು ಪೊಲೀಸ್ ಇನ್ಫಾರ್ಮ್ಡ್ ಹಿಮ್ ಥ್ರೂ ಫೋನ್ ದಟ್ ಯುವರ್ ಬ್ರದರ್ ಸಸ್ಟೈನ್ಡ್ accident and died at the spot.
That is a complaint.
Next exhibit P4, you last kindly see.
Yes.
It is the vehicle seizure measure. Vehicle seizure measure.
I have filed a translated copy of the
Vehicle seizure measure. And the very 16.
No. before seizing the vehicle, you gave your additional restatement on 16 to 2019.
Yes.
It is not that police have informed you that this vehicle is involved.
Yes.
You have informed the police this vehicle
No,
is
no.
involved.
In the further statement also, my lord,
Read it,
stated.
let you
Yes,
read it.
ನಾನು ನಮ್ಮ ಅಣ್ಣನ ಅಂಬರೀಷ್ ನಾಯ್ಕನಿಗೆ ನಂದಿಗುಡಿ ಗ್ರಾಮದ ಹತ್ತಿರ ಯಾವುದೋ ಒಂದು ವಾಹನದ ಚಾಲಕನು CH-23 ರಸ್ತೆಯಲ್ಲಿ ಯಾವುದೋ ಒಂದು ವಾಹನ ಚಾಲಕ ತನ್ನ ವಾಹನವನ್ನು ಅತಿವೇಗ ಹಾಗೂ ಅಜಾಗ್ರತೆಯಿಂದ ಚಲಾಯಿಸಿ ರಸ್ತೆಯಲ್ಲಿ ನಡೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದ ನಮ್ಮ ಅಣ್ಣ ಅಂಬರೀಷ್ ನಾಯ್ಕನಿಗೆ ಅಪಘಾತಪಡಿಸಿ ನನ್ನ
First of all, you have filed the complaint against the driver of the vehicle on the morning at 6 to 19.
Yes.
Then later this evening, police informed me that they had located the vehicle.
Yes.
So
They found the vehicle.
How did you know?
No, they found the vehicle. Police found the vehicle. That is come in the vehicle seizure measure.
Police found the vehicle.
Police
you
only.
gave the number, you gave the vehicle, you gave the number, the details to the police.
Police only.
Basing on that, police have located it.
Police only, my lord, seized this vehicle, my lord.
You're not understanding the court's question. I said, police will only seize a vehicle, you can't seize a vehicle.
Yes, ma'am.
Police have seized a vehicle basing on your information. Where is your information?
Not my information, my lord. Police
At least this translated copy, according to you, the translation is done correctly or wrongly. That you can tell the court.
Not proper, my lord.
According to you, what is the proper translation? You please translate.
Further statement, one line I read, my lord.
Yes.
ಈ ದಿನ ಸಂಜೆ ಮರೆಮನಹಳ್ಳಿ ಪೊಲೀಸರು ನಿಮ್ಮ ಅಣ್ಣ ಅಂಬರೀಷ್ ನಾಯ್ಕನಿಗೆ ಅಪಘಾತಪಡಿಸಿ ಹೋದ ವಾಹನ ಮತ್ತು ಅದರ ಚಾಲಕನನ್ನು ಪತ್ತೆ ಮಾಡಿಕೊಂಡು ಬಂದಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದರಿಂದ ಈ given this statement, police informed him that he found the offending vehicle and brought the vehicle to the police station. He police informed him, hence he given this further statement.
Yes, Mr. Shivanagowda, you read that thing and translate it to the court. The further statement.
ಗೊತ್ತಿಲ್ಲ. ಈ ದಿನ ಸಂಜೆ ಮರಮನಹಳ್ಳಿ ಪೊಲೀಸರು ನಿಮ್ಮ ಅಂಬರೀಷ್ ಅವನು ಅದಕ್ಕೆ ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
First step one, you read the first one.
What the statement of the complaint is that, my lord, based on the information given by the police, he has given the further statement. Now the question is how the police have gathered this is the
Not that. What the translated copy he has filed before this court is, our elder brother was hit by some driver of a vehicle near so and so. The driver of the vehicle was driving his vehicle at high speed and recklessly and caused an accident to our elder brother who was walking on the road, and I filed a complaint against the vehicle. I filed a complaint against the vehicle and its driver on the morning of 16 to 2019 at the police station. Later this evening, police informed me that they had located the vehicle. There is a difference in both of in what you are saying and what I am reading here.
In Kannada, it's very clear.
Now, as per this translation, he has given the details of the vehicle to the police. Police have located it.
Correct.
And what you are saying is
that is contrary to this.
Exactly contrary is your submission. So what what actually it is there in Kannada?
In this case, my lord, only based on the information given the police, he has given the further statement of vehicle regarding the vehicle number. That means complaint is not seen the vehicle, or he is not aware of the which vehicle is met with an accident. Only on the basis of the police.
Where is the charge sheet? Is the charge sheet part of the
Charge sheet part of
what they said? How did they find the vehicle?
In the
spot mark exhibit P4 I filed.
P4 is there.
Exhibit P4.
Let's see. Then why the translation is filed like this, exactly opposite to what is written?
No, but it's exact translation of the whatever is stated in the exhibit P2 and P4. There is no changes, sir, my lord. May read again.
No, I understood. The complaint is that he has given the first, he has
on the information of the police, he has filed the complaint.
That is one.
Yes.
Then with
Stating
regard to the
that
vehicle number, he has only given the
vehicle number was not given on the first day. Stating that some unknown vehicle as it is.
No. Our elder brother who was working on the road, and I filed a complaint against the vehicle and its driver.
Yes.
On the morning of 16 to 2019.
That is. Your Lordship,
Later
exhibit,
this evening, the police informed me that they have located the vehicle.
exhibit P4 is there. Your Lordship.
Let's see.
On 16/2/19, Sandur Circle Police CPI, the Malkund took us to a Maruti vehicle car standing in the premises of Mariammanahalli Police Station, and confiscated the car and called us as Pancharu and told us about the incident and showed us a person who was walking there, whose name was Marigoda MC, son of Chikkegoda, car driver, resident of Bhagat.
Please, where is the charge sheet? In the charge sheet, what did they say? How they have come to know about the involvement of the vehicle?
As police found in the way, when he was going to Davangere, his vehicle was damaged.
It is stated
Police stopped the vehicle and inquired the accused. He informed about the accident. Then on the very same day, that vehicle is brought to the police station.
By hitting the person, the vehicle is damaged.
Yes. No, police doubted his activities and stopped and inquired him because.
Let's see that. What is
the exhibit P4? It's a continuation. It's there. It is referred to. Your Lordship, on 15/2/2019, at 9th line, at around 10 p.m., we crossed Mariammanahalli and reached SFR. While driving my it is stated Mastigoda statement, it seems. While driving my car on the road, I suddenly saw a person walking on the left side of the road, and I was so scared, and I hit the person walking on the road by driving the car at a high speed and could not control my car. I did not stop my car there and drove towards HB Alli. Later, when I was coming to Davangere at night, the police stopped my car at Harappanhalli and checked it. The front and left side of my car were damaged in the accident. The police stopped the car. Then Mariammanahalli police came to the Harappanhalli and took my car and me back to Mariammanahalli police station. I was the one who caused the accident. Due to this accident, it was found that Ambarish Naika, a resident of Mariammanahalli, Tanda, died on the spot. Then the five checked the car and found that it was Maruti Desire company car. The number of the car was so and so, and it has a white board. It was silver in color, and the car was currently in neutral gear. The car was parked in the premises of Mariammanahalli police station. The front bumper of the car was damaged due to the accident. The left door, the foot stand, the mudguard of the rear wheel, the mudguard of the front wheel. There was a wound on the side. The estimated value of the car was 3 lakh rupees, and the CPIs have confiscated the car with PAP number so and so. The check of this place came, and Mariammanahalli police station was to the east. I'm sorry. Schedule. The station premises are to the west. To the north, the road. The south, the police station premises. The Panchanama is confiscated.
All this appears to be. You should have at least examined that investigating officer. What is this?
Charge sheet is filed against the driver.
Does it inspire any confidence in the mind of the court? We have to at least no connection. Night time, somebody is going and somebody somewhere has found. And in the morning, all this has happened on 15th. By morning 16th.
No, night only, Malas. Night only.
15th night this happened. When you see the complaint, initial complaint on 16/2/2019, by that time, police have not told him that so and so has said nothing. You know by 16/2 when you are giving the complaint.
Then Malad, the next station police found that Malad the damaged car, and after inquiry, Malad they revealed the real facts. Then this car is brought to the Mariammanahalli jurisdiction police station and ran the Maza investigation. IMA report last candidacy. The last permits me, I will examine the IVA Malad.
If the police department works with this kind of, so many things can be solved.
There are some areas where we can't even imagine how the
IMA report last candidacy.
You examine the concern. I'll set aside this thought. Agreed with the award passed in MBC number 317/2019 dated 14th November 2019, whereby the Court had granted compensation of an amount of rupees 8,40,000 and held that the accident has taken place because of the rash and negligent driving of the driver of the car. Both the insurance company as well as the claimant are before this court. The insurance company's appeal is MFA number 2826 of 2020, and the claimant's appeal for enhancement is MFA number 3859 of 2020. Learned counsel appearing for the insurance company submits that the involvement of the vehicle itself is doubtful. For this purpose, he has relied on Exhibit P1, Exhibit P4, Exhibit P2, Exhibit P4, and also Exhibit P9. As per the case of the complainant, who is none other than the brother of the deceased, he was informed by the police that his brother met with an accident. And accordingly, he came to the police station and gave a complaint on 16/2/2019. As per the said complaint, it is a case of hit and run. Then on the evening 16/2/2019, another restatement is given wherein it is stated about a car and the driver that is involved in the accident. And Exhibit P4 is the Mahajan, where it says that the driver himself on the night of 15 has confessed before the police that he hit a person and he died at the spot. Learned counsel appearing for the insurance company submits that this vehicle is implicated in this case only for the purpose of claiming the compensation. The claimants have not taken any steps to prove the case that the deceased was hit by the insured vehicle, driver of the insured vehicle. It is submitted that without any basing on the charge sheet, the court had granted compensation. Next learned counsel appearing for the claimant submits that the charge sheet is filed against the driver of the offending vehicle. The charge sheet is not questioned. That itself shows the involvement of the vehicle. It is submitted that Exhibit P2, P4, P5 supports the case of the claimants, and the court had rightly considered and granted compensation. He submits that the claimant, the compensation that is awarded is not a reasonable compensation, and they're seeking enhancement of the compensation. Next, having heard the counsels on either side, peruse the material on record. This court has perused Exhibit P2, P4, P5, and this court finds force in the argument of the learned counsel for the insurance company. When it is on 16th morning, when it is a case that it is a case of hit and run and the vehicle is unknown, by evening 16th, it is stated that some vehicle is involved, and on the night of 15th itself, police have arrested him. It is confessed to the police that he has hit the deceased and the vehicle is involved. In support of their case, neither they have examined the brother who is the claimant, the brother who is the complainant, nor they have examined the IVO. When a petition is filed under 166 of the Motor Vehicle Act, the burden lies on the claimant to prove that the accident had taken place, and the same is because of the rash and negligent driving of the driver of the offending vehicle. In this case, as the evidence on record do not inspire confidence in the mind of the court. In that view of the matter, this court, balancing the interest of both the parties, also remand the matter. And hence at this stage, this court is not inclined to go into the enhancement aspect. Accordingly, the court is passing the following order. The order dated so and so is set aside, and the matter is remanded to the court for fresh consideration. Number two, both the sides are at liberty to adduce evidence, if any, and basing on the evidence, the court shall pass appropriate orders. The amount in deposit shall be forthwith transferred and shall be in a fixed deposit.
Cell number 20, Shivakumarappa.
Without further notice, the party shall appear before the court on 22nd September. 22nd September, within 6 months from the date of receipt of the copy of the order, they shall proceed with the appeal shall be disposed, the petition shall be disposed of.
Office member director send the LCR.
The order that will be there. Yes.
Cell number 20, Shivakumarappa TC. For appellant.
Climate appeal for harassment.
Who appears?
Yes.
Yes.
And I have filed for further treatment. I have filed for produced medical bills and prescriptions for further treatment.
What about your, have you filed your objections?
Objections already filed.
Filed. What are your objections to that IA?
Objections not on 448 minutes are filed. Some of the documents there is no possible explanation why has not produced before the tribunal.
After disposal of the petition, further treatment is taken.
And somebody should be examined. Then, as far as that is concerned, IA is concerned, you will remind the matter to that IA and you examine.
Please.
IA number 1 of 24 is filed. IA number 1 of 24 is for production of the additional documents, whereby the claimant has produced before this court the documents to show that after the disposal of the case, he has underwent some, he has spent some amount to that he has spent some the medical expenses for the treatment. The respondent has filed his objections to the same. This court deems it appropriate to remand this matter to the court as far as deciding this, as far as remanding the matter to the court, and the court should decide IA number 1 of 24 by giving due opportunity to both the parties. Without further notice, the party shall appear before the court on 24th of September, and within 2 months from there on, the court shall dispose of the IA 1 of 24 and shall and as far as that, the finding shall be the order shall be passed and shall be sent back to this court. Once the order is received from the trial court, this is matter. Is there anyone?
Cell number 21. Cell number 21, Kuldev Prasad KT. Appellant.
You are appearing in?
Okay.
21.1, madam. Filed challenging liability, pay and recovery order is there. It's the third party, my lord.
It's what, Mr. Gurudev Prasad is not here. Passover or adjournment?
Adjournment.
If it is adjournment, it will go a long date. Or if you want, I'll pass over.
Passover.
Just pass over next.
Kindly have it next
Next
week,
week, it's not possible. It will come up in the month of November, 12th of November. Yes, next.
Cell number 22.
Insurer appeal on liability, please, DL.
Yes.
And also percentage of
If it
disability
is on
quantum.
DL, pay and recover will apply. What is the difficulty in withdrawing the amount? IA number 1 of 23 is filed seeking to withdraw the amount.
Ready for disposal, please. Ready for disposal.
Ready?
Please.
Yes. What grounds? Only that?
Liability, one DL, another one is percentage of disability, please. Doctor deposit 32% to the whole body. The entire amount considered by the learned judge. Fracture is tibia and
Please
fibula.
come to the table.
Judgment number 20, please.
Yes. That is at page number, internal page 20, paragraph 32 is the
Please, ma'am. There is a table.
pain and suffering 20,000. How many fractures?
Two, fibula and tibia.
Hmm. So you are only on loss of future earning.
Please, ma'am.
You are only on loss of future earning.
Future earning.
What is that? What is wrong in it?
Lord, 32% divided by 11, 2 and 3, it comes to 10.66. Whole body
Where
disability.
is the doctor's evidence?
Lord, doctor, it is at page para 26 of the judgment plea. It is taken 11% or 10% please, or 11%.
No, there is no discussion. Para 24.
Please, ma'am.
Para 21 and 24. my lord.
They're having disability of 32% for the lower limb.
It is limb disability, not assessed the functional ability or whole body, please, ma'am.
It comes to 11%.
My lordship, there is a judgment from the apex court.
Take the judgment.
My lordship, in this judgment, my lordship, the Supreme apex court held that, my lordship, para 12, my lordship, page number 9,
About
disability. In that point number 3, my lordship, if the disabled percentage is expressed with reference to any
No, paragraph number 9.
Page number 9, para 12, in that point number 3,
Where do you get the page numbers here?
top, my lordship, top of the page, second line, top of the
Judgment
page.
is there.
No, it is not. It is showing as page 56, page 58, like that it is there.
My lordship, kindly see para number 12.
Therefore, the tribunal has to first decide.
Here, my lordship, page number. Top of the page.
Yes, page number 9, yes.
Para 53 onwards. Page 58, para 12. In that point number 3, my lordship.
There is nothing new in this. It is settled law. We have to consider the disability basing on the, generally it is 1/3 of the limb disability is a whole body disability. That is the general norm. Why it is an exception that you have to tell the court.
My lordship, again, my lordship, in this month, there is a removal of implants. There is 12 injuries. In that, 2 injuries are grievous injuries, and he was working as a mason, and in some occasions he used to work selling the plastic buckets. In the doctor's cross-examination, he clearly stated that he is not able to sit and work. He need to, if he need to work, he need to sit in the chair and work.
But you cannot take the disability at limb disability at 32% in spite of all this. So what was the income taken?
11,000 taken by the.
Repeat 14,000, my lordship.
You have not preferred any appeal.
As per order 41, rule 33, my lordship have description power to enhance the.
Oh, then in that case, in every case, we start doing it for the insurance company also.
No, my lordship, please. As per
No, in
order
that
41,
case, what we do is, in every case, insurance company do not prefer any appeal, and we'll say that insurance company is not liable because under so and so. That's not the way how it works. Yes.
11,000 into 11% into 12 into multiplier.
11,000?
11,000 into 11%. Sorry, 11,000 into 11%
Into
into
12
12 into 16, please.
16 into 11.
Multiplier. Was
Multiplier
there
is
35
16.
years.
Anyhow, we are reducing this. We will take that as per the chart.
Please.
How much it is?
14,000,
14, not
2019.
They are not 11,000 to be considered, please,
My
madam.
lordship, there is a judgment, reported judgment from dishonour court on that effect, order 41, rule 33 also, my lordship. My lordship may enhance.
It comes to 2,95,680.
Please.
Yes. Then what about the other heads?
Other heads, the pain and suffering, 20,000 given by the tribunal placement for 2 fractures. They are not in appeal, we are in the appeal. Alluded losses.
60,000. The medical expenses as it is.
Actuals.
1,18,154.
And future medical expenses also granted 25,000. And amenities 15,000 and laid up period with 10,000.
How many days he was in hospital?
9 days.
Reasonably granted. Loss of amenities another 15,000 be grant. Ultimately, yeah, the court has granted 6,75,840. Now it is coming to 2,95,680. So it doesn't matter much for
Just
insurance
consumption
company.
concept, it can be done, please, madam. They are not in appeal. That's my humble submission.
That is that court is also conscious of
Please.
it.
After
Later period, we are taking 14,000 for 3 months.
for 14th, 11,000 kindly consider.
14,000 as
No, no.
per the chart,
Learner just taken 11,000.
but we are taking 14,000 as per the chart. 2,000. Yes.
Pay and recovery, please, madam. Before taking in pay and recovery, my humble Supreme Court said that unless an owner has to furnish the surety, then only amount to be released to the claimant.
Please don't complicate it.
Not completely. The Supreme furnishing the Supreme Court judgment, please.
It is there.
Nanjapan case, please.
I'm aware of it. It's coming to 5,86,334 against 8,78,994. Now, where is that the liability issue?
Liability, they have not at all discussed it in this case. Directly fixed it against us, please.
Where is at least there should have been an issue with regard to that.
We have let the evidence, taken the defense, produced the charge sheet.
Where is that? Let us see where your contentions are in that regard.
My Lord, para 28, judgment page number 17, please. Charge sheet alli, they have leveled the section 3, 181 of MUA Act. They have given the reply also, there is no DL.
Where is that level?
He had
It
LLR,
is in
my
the,
lordship. He had LLR. For two-wheeler, there is no required for instructing person
Where is
for
that?
LLR.
First, let me at least understand. Which paragraph,
Page,
where?
Para 30, my lordship, page 17.
Even though, please read.
Even though respondent number 2 raised the contentions that the driver of the offending vehicle is not having driving license, but only is having LLR, accordingly, the respondent number 2 is not liable to pay compensation. In this regard, learned counsel for the claimant relied upon a decision reported in 2019 MAC 426 arising out of MFA number 20655 of 2011 dated 21/8/2019. In between senior.
But if there is a learner's license, somebody should be there. The pillion rider should be having the
For two-wheeler,
license.
it is not required, my lordship. For two-wheeler, it is not required.
she is arguing on behalf of the owner also, please.
What is that?
For two-wheeler, it is not required. For four-wheeler, only instructing the person is required.
Is it so?
In this
Shivanagoda.
judgment also it's held that.
Rule 3 of the central government rules,
Also not
it
aware
requires
whether
one
on
man
what
to
basis.
give the instruction to the two-wheeler also, please.
That's what it is.
She's referring some judgment, Malad. We have not gone through that judgment.
For
But
two-wheeler,
as per
it
the
is not
central
required.
motor vehicle rule, Malad,
That's
there
what we
must
have
be
been passing orders.
some instructor to ride the motorcycle.
Even for a two-wheeler also.
Also,
Two-wheeler
Is
is
that
must.
judgment?
But,
This court judgment?
This court, my lordship. And referred Supreme Court judgment.
2019.
2019.
Pass one? Why there is a
Noted.
exception between the two? Hmm.
Para 17 onwards, my lordship.
Which means a person who is having learner's license and learning driving of four-wheeler vehicle shall always accompany an instructor. On bare reading of Rule 24(3) of the rules clearly provides that the instructor shall accompany with the learner while driving the motor vehicle. Yes? Paragraph 24.
Paragraph
24.
please.
There is a Supreme Court judgment. No Supreme Court judge.
There is a Supreme Court judgment, my lord, learner license is also a valid license, but pay and recovery, if the
is true.
violation, pay and recovery,
What is the violation?
the instructor is not
Correct.
there.
There is a
And the
judgment in that
vehicle was
regard.
not having a L plate, a learner's like plate front and back of the motorcycle.
That is one violation.
Please.
What is the other violation? Instructor.
Instructor.
Which judgment is that?
In that judgment of Muhammad Tamre versus, it may be have it on.
Because this judgment runs contrary to the whole. Now, where is the distinction between a
If that
four-wheeler
is,
and?
if that is written, my lord, it is violation against to the provisions of the central motor vehicle rule.
That's what. Yes. Let's read. 20. Which para we were reading with regard to this license?
24. In the
30.
30.
30, my lordship.
Hmm. So in this case, the person who is having the learner's license alone is driving, nobody else.
Nobody.
Where do you, is it, that fact is clear?
Clear, my lordship.
Please come. Agreed, Pedro.
But in this case, court has distinguished the motor vehicle and motorcycle. That is not there in the provision.
Correct. That's what four-wheeler, two-wheeler.
That's what distinction must mean.
Agreed with the award passed in MBC number 463 of 2020, whereby the court had granted compensation of an amount of rupees 8,78,994, which is rounded off to 8,79,000, and the liability is fixed on the insurance company. The insurance company is before this court. Learned counsel appearing for the insurance company submits that when the doctor has opined that the disability to the whole body, to the disability to the limb is that, what happened?
Para 25, they have clarified that we have not taken defense, we have not accused any of that. Therefore, court has not on the.
In this case, you have taken the defense
But
against the evidence
that
produced in
was
the
contrary to the act itself.
No, that's what they have clarified in para 25, the judgment of the particular.
The doctor has reported that the disability to the whole body is 32%.
Limb disability 32.
Limb disability is 32%. The court had taken it as a whole body disability
and granted the compensation. It is submitted that the compensation that is awarded is on the higher side. Then coming to the liability, there is no dispute about the fact that the driver of the opposite vehicle is having a learner's license, but there was no other person who is instructing him. The person, no other, there is no pillion rider who is instructing him, who is having a driving license to drive the vehicle. It is submitted that on both these counts, the appeal of the insurance company has to be allowed. Learned counsel appearing for the respondent submits that the court, considering the work the claimant was doing, that as he is a mason, court had taken 32% disability, whole body disability, and she relies on the judgment of the apex court in case of TJ Parameshwarappa versus branch manager, New India Insurance Company, reported in 2022-17 SCC 51. It is also submitted that the court under the other heads has not granted a just and proper, just and reasonable compensation, though there is no appeal preferred by them. Still, considering the material on record, the court can grant a just and reasonable compensation. Next para. Having heard the counsels on either side, there is a material on record. First, coming to the aspect of liability, it is an undisputed fact that the driver of the offending vehicle is having a learner's license and he is alone driving the vehicle. In that case, there is violation of terms and conditions of the policy. The law laid down by the apex court in Sorensen's case applies to the facts of the case, and even in that case also, the principle of pay and recover will apply. The insurance company is liable to pay and record the same from the owner of the vehicle. Then coming to the compensation, the claimant had sustained 2 injuries, and the tribunal had awarded 20,000. Though the claimants have not preferred the appeal, while the court is considering the aspect of compensation, this court has to balance the interest of the parties and as the Motor Vehicles Act is a beneficial legislation. Hence, considering the 2 fractures he has sustained, under the head of pain and suffering, this court is granting 60,000. Coming to the disability, court ought to have taken 1/3 of the limb disability as a whole body disability, then it comes to 11%. But the court had taken the income at 11,000, which is on and the accident had taken place in the year 2019. And as per the table, this court is taking 14,000. 14,000 into 12 into 16 into 11 by 100 is 2,95,680. Medical and future medical expenses basing on evidence court, future medical evidence conveyance, court had granted as per the evidence and no interference is called for. Coming to the loss of amenities, considering the disability of 11%, this court is granting 30%. Loss of income during the later period, considering the hospitalization and the injuries, 14 into 3, this court is granting 42,000. Altogether, the claimant is entitled for an amount of rupees 5,86,334. Accordingly, the appeal of the insurance company is partly allowed, reducing the compensation from 8,78,994 to 5,86,334. The amount insurance company is liable to pay and record the same from the owner of the vehicle. The amount in deposit shall be forthwith transferred. Yes.
Deposit the 4,81,000 plus 25,000 before this honorable. Kindly transfer that amount, please.
Which I already said. Yes, next. Partly allowed.
Case
Yes.
number 23.
Amount in deposit, kindly transfer the.
In every order, it will be there.
Raja L for appellant.
This case appear for the appellant.
Respondent.
Yes.
Case of injury seeking for enhancement of the compensation
Come to the table, MFA 920.
920,
There are 2 MVCs. MVC
967, 968.
Yes.
This
MVC 967,
is 910, MFA number 910.
910.
It is 968, 920.
9?
20 of
920.
MA pen,
So first is MFA 920.
920.
920 arising out of 968.
The case of injury, my lord,
Where is table in 968?
in synopsis, page number 2 nalli.
Not synopsis in the order.
Order.
Is at page 36 of the judgment, my lords.
36.
Yes, my lords.
In
Internal page 36 of the judgment.
The
Yes.
pain and suffering 40,000.
What are the injuries?
The case of several injury in ink page number, my lord, 960.
29 of the judgment, my lords.
29.
Yes, my lords. From the top, about 6th line.
38.
Focus. What are the injuries?
He had a
That's
fracture
also-
of left pubic rami and left acetabulum.
2 fractures.
Yes, my lords.
And also
So for
right
pain
knee
and
joint.
suffering, we'll grant 60,000. Next.
And,
How many days he was in hospital?
27 days, my lord.
Nourishment, conveyance.
He is an
and all.
employee.
So how many days? 27.
27
So
days.
27,000. Then
He is
medical expenses as it is,
Same. Medical episode, 96.
1,46,700. What is the income?
Income
My lord,
41,000. He is working in the.
He has continued in the same job, my lords. That's the reason future loss of earning is not awarded by the
So loss of income during the
that is 2
41
months is awarded, my lords. 26,000 into 2.
will grant another 26,000 is the salary.
Yes, my lords.
This is 40 or something.
41,000.
My lords, your lordship may find it at page 35 of the judgment. Loss of income during later period, my lords.
In the ink
What,
page,
I am asking, what is his income considered by the
ink
court?
page number 15. my lord.
Considered is 26,000, my lords.
But salary is 41. Ink page number 51, trial court discuss the matter.
Ink page 51.
15, 1-5. He MUC 968 of 2000 working the administrative officer, Milk Union, KMF, Gejligere, earning of 41,000 for month.
Where are you reading?
Ink,
You
ink
can
page,
refer to the paragraphs.
paragraph number 2, my lord, judgment.
Those are all the facts.
Contentions by the
Paragraph number 2 are the facts. Where is the evidence?
the 35 is the finding, my lords. Page 35 of the judgment.
Page 35.
Yes, my lords. Loss of income during later period.
Yes, that is internal page
26,000.
24 of the judgment.
Yes, my lords.
Admitted in India as inpatient 27 days.
Yes, my lords. Due to the accidental injuries, petitioner was forced to take bed rest. Considering the nature of injury sustained by the petitioner.
Where is the evidence with regard to your income?
Income is, salary certificate is produced, my lord,
Whom you have examined?
not examined.
Not examined in.
Then on what basis court has taken 25,000? Because accident is of the year 2018. If
Yes,
the
ma'am.
table has taken, it can't be 25,000. So on what basis it has taken?
There is a salary slip that is produced at exhibit P29, my
That
lords.
is according to him 41,000.
It doesn't have a copy, even I have not seen it, my lords.
PCR is there.
TCR.
Please take that exhibit.
P29, my lords.
P29.
Salary slip.
What is the amount?
That is total amount 32,124.
How much?
Net pay is 32,124 and gross is 41,835.
There should be some basis for the court to take. Why 25,000? Why not 41?
But they've not examined the author of the document, nor his
Where are you
employer is
working?
summoned.
He
was working in,
KMA Milk.
Milk Federation, my lords.
Milk Union, Mandya.
Some amount will take in between instead of again demanding the matter back.
Yes. Already, the tribunal has taken 26,000. That can be taken, my lords.
We will make it 30 for
Yes.
3 months. Yes, next. Loss of future earnings at 99,000. What is this? No, it is not in this. Yes. Discomfort due to disability. That is the loss of amenities.
Amenities is also given 15,000, and along with it, discomfort.
15,000. It is.
No, at the
Loss
top,
of
my
amenities,
lords. Yes, yes, my lords.
Disability is how much as per the doctor?
Doctor says he
15%.
has got a 15%, but it is the admission by the claimant that he has continued with the same job, and there is no reduction in his salary. That's the reason tribunal has not awarded any amount under loss of future earning capacity, my lords.
And in that case, for the loss of amenities itself, we will
Loss of
increase some more amount.
Yes, yes, that can be given, my lords.
Yes.
So loss of amenities, court has granted 15,000. We'll grant 75,000.
15 plus 50, it will be around 65, my lords. This disability aid also is granted.
75,000 disability. At his salary, future prospects, his loss of future earning is considered. It will come to a very big amount. 10,000 legal expenses. It's coming to 4,58,700 against 3,28,700. So please come to the other case now.
Is
This is
In-
900.
It's 967.
910.
967.
910.
Is also case of injuries, my lord.
910 arising out of
967.
960.
Page, this is
In the injury.
1 minute. Paragraph number 32.
Injury is at page 17 of the judgment,
No,
my
no,
lords.
paragraph number 32,
The breakups is at page 24, my lords.
24. What are the injuries?
Injuries, your lordship would find at page 17 of the judgment, my lords. From the top third line, my lords. Pubic rami fracture, left clavicle fracture, multiple rib fractures, and left side, and hemothorax on left side. These are the fracture injuries, my lords. Yes.
We have
80,000. Yes,
inpatient 27 days also, this.
nourishment attendant 27,000. Yes,
Doctor assessed disability is
medical
20%.
expenses 1,90,000. 90,500. So what is the disability according to the doctor?
20% permanent physical disability is the
Loss of future. What is a whole body disability?
tribunal is taken only 6% in disability.
What is the evidence of the doctor? What is the limb
Doctor
disability?
is 20% permanent physical disability is stated
Where is the evidence?
in the
Paragraph number?
20, my lord.
Yes.
By considering a restriction movement of the lower limb, left shoulder, is hip and reduction physical power, CW1 in opinion, the petition as suffering from 20% permanent physical disability.
He has not stated it for the whole body, my lords. He had a clavicle fracture and
He says by considering the restricted movement of lower limbs, both the limbs, left
But-
shoulder and hip.
the nature of the injury is pubic rami fracture.
No, every part of the body is involved.
Yes, but the fracture is restricted only to pubic
Where is
rami
this evidence?
and
Look
ribs
at it.
fracture
Look at it.
and clavicle fracture. So
Is
the
examined
clavicle
as-
fracture would not
Doctor is examined as.
CW1, my lords.
Look at it.
CW1. CW1.
Doesn't appear from the annexure.
CW1.
Where is the disability certificate? Discharge summary, salary slip. No disability.
There is no
certificate.
disability certificate.
CW1 na madam.
All fractures were treated conservatively. Pain and stiffness in the left shoulder, groin and mid-back pain. Inability to lift at her right and left hips and to sit across-legged. Range of movement of right and left hip is restricted and terminally painful. According to the guidelines of the Ministry of Social Justice and Empowerment notification, I have calculated the disability after clinically assessing the patient. I have assessed her to have 20% disability.
It doesn't say whether it is for the whole body or the particular limb. Nothing has been stated, my lords. That is what has been extracted by the tribunal in the judgment as well, my lords.
I think it is a limb disability. What he says is, it is not true to suggest that I am deposing falsely in order to help the petitioner of 50%, 15% disability. It is not true to suggest that to help the patient, I am exaggerating the permanent disability of 15% in left foot. I have narrated the disability as per guidelines of the Ministry of Social and Empowerment notification of 2018 and my experience.
Not sir, disability to the left foot would not arise because pubic rami fracture and clavicle fracture. These were the injuries and multiple rib fractures.
If it is a limb disability is that much, whole body has to be 1/3 of it.
15% taken.
How can it be taken 15%? Court had taken how much?
6%.
6% only.
So we take it 10%. Or else you have to remind the matter again, another round of litigation.
No,
10%?
about 8%, my lords.
And what is the, how much
Because
is the amount?
the injuries itself
No,
is
amount is taken how much?
12,500
12,500.
as per the chart.
As per the chart.
Yes, my lords.
2018 accident.
12,500 is taken, my lords.
So 12,500 into 12,
11 is the multiplier, my lords.
11 into, we'll take 9,
Yes,
9
ma'am.
by 100. It's coming to 1,48,500.
1,48,500.
500 it's coming. Then loss of amenities. There is a table, page number 34.
Yes, ma'am.
Internal page
24, my lords.
Ah,
24.
Yes. So loss of amenities, another 5,000. 20,000 is granted,
Yes, my
15
lords.
is granted, another 5,000. Then loss of income during laid up period,
2 months is granted, another 1 month.
another 1 month. 12,500 into 3,
37,500.
37,500. Yes, legal expenses, 10,000. It's coming to 5,81,000 against 3,94,500. Please come. Take 2 different orders is better. Agreed with award passed in MFA, MVC number 910 of
968.
967 of 2018. The dated 30th September 2022. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. That is at page 24, para 24 of the order. Then counsel appearing for the claimant submits that the claimant had sustained 4 fractures, but the court has granted only an amount of rupees 40,000 to his pain and suffering. He was there in hospital for 27 days. Court has granted only 25,000. Even under the head of loss of amenities, also the amount that is granted by the tribunal is on the lower side. It is submitted that the doctor has opined that the disability is 20% to the 20%, and the court had taken 6%.
Yes, my lord.
6% as a disability, which is on the lower side. It is submitted that on all the heads, the compensation that is awarded by the tribunal is not reasonable. Then counsel appearing for the respondent insurance company submits that the doctor has not stated anything, has not specifically stated that the disability is to the whole body. Court had rightly considered it as a disability to the limb, and 8% is taken as a disability to the whole body. It is submitted that on all counts, the tribunal had granted a reasonable compensation and no enhancement is called for. Next para, having heard the counsel so and so, so and so. This court has perused the order, perused the award, and particularly the injuries that are sustained. Yet the claimant had sustained as many as 4 as many as 4 fractures. Hence, this court is granting an amount of rupees 80,000 towards pain and suffering, towards nourishment and conveyance charges. Considering 27 days of hospitalization, this court is granting 27,000. As far as the medical expenses are concerned, no interference is called for. Coming to the loss of future income, as rightly submitted by the then counsel for the insurance company, the doctor has not stated whether it is a limb disability or a whole body disability. This court has perused the evidence of the doctor, and considering the evidence of the doctor, this court is inclined to take 9% as disability instead of 6% as taken by the court. The court had rightly taken the income at 12,500. 12,500 into 12 into 11 into 9 by 100 is 1,48,500. Then coming to the loss of amenities, considering the disability, this court is granting 20,000. Loss of income during the later period, as he is already in hospital for 27 days. This court is considering for 3 months, and it comes to 37,500. In the light of the law laid down in make losses so medical legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 5,81,000. And accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 3,94,500 to 5,81,000. The next matter, that is MFA
920/23.
MFA 920, agreed by the award passed in MFA number 968 of, is it 968?
Yes, my lords.
968 of 2018. MFA, the dated so and so, the appeal is filed, that is MFA 920. The court, considering the court, where is the table here?
Page 36, my lords.
The court 32.
36.
36. Yes. Paragraph number 32.
Yes, my lords.
The tribunal has awarded the compensation as per the table given below. Paragraph 32, extract. Land counsel appearing for the petitioner submits that, considering as per the evidence of the doctor, he had sustained the disability, and the court has not granted any amount under the head of loss of future income. Even for the loss of amenities also, amenities, pain and suffering, nourishment, the amount that is granted by the court is not just and reasonable. It is submitted that on all the counts, the amount needs to be enhanced. As per the evidence of, as per the salary certificate, his salary is 41. Court has considered 25,000 as salary. That is also needs to be enhanced. Then counsel appearing for the respondent insurance company submits that he was continuing to work in the continue to work, and there is no loss of earning. As such, the court had rightly not granted any amount under the head of loss of future earning. It is submitted that though he has filed the certificate, he has not examined any person, the salary certificate, he has not examined anyone in support of the same, and the court had rightly not taken 41,000. It is submitted that there are no grounds to interfere. Next, for having heard so and so. Considering the 2 injuries that were sustained under the head of pain and suffering, this court is granting 60,000. As he was in hospital for 27 days for nourishment, this court is granting 27. Medical expenses, no interference is called for. Coming to the loss of income during the later period, the certificate shows that his earning is 41,000. Court, the salary certificate shows that his salary is 41,000. Court had taken 25,000.
26, my lord.
26,000. Why court has taken 26,000? There is no evidence at this point of time. Instead of remanding the matter to the court for determination, this court is inclined to take 30,000. Considering the hospitalization of 3 months, 27 days, this court is granting the loss of income during the later period as 3 months. It comes to 90,000. Loss of amenities as the disability. How much is it?
15%.
15.
To the whole body.
15% to the limb.
Considering the 15% disability and the impact it is going to have on his life, though as he is continuing, he is not entitled for the loss of income, loss of future income. Considering the disability and its impact on his future life, this court is granting 75,000 for the loss of amenities. the court had granted an amount of rupees 50,000 towards disability, that this court is not interfering in the light of the law laid or in so and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,58,700. And accordingly, the appeal is partly allowed by enhancing the compensation from 3,28,700 to 4,58,700.
Much obliged. Grateful, my lords.
Yes.
Cell number 24 urgent, cell number 25.
For second,
the name.
second
24
response.
is adjourned. Yes. Yes. It's time is done. Yes.
This is a claimant appeal
Hmm.
challenging the liability and also the quantum of compensation awarded
Liability is fixed on the owner.
owner
On what ground?
on the ground that the deceased was only a gratuitous passenger. The accident occurred not during the course of the employment, and last ground is
Placing under ECA or the?
the MA Act, MA Act. And the last ground that there is no employer and employee relationship between the owner of the lorry and the deceased.
That finding paragraph number,
Paragraph number 32, my lord. Judgment paragraph number 32.
please come to that. It is a case that you are a coolie.
Yes, I am loader and unloader
Where are you
appointed
sitting
appointed by the driver of the lorry.
at that time
At
when
that
the
time.
accident has happened?
Yes, my
Where are
lord.
you sitting?
The lorry was taken for unloading tomato to Kolar.
Are you in the cabin? Are you in the?
I am in the cabin, my lord.
Hmm.
So kindly look into the para number 32 of the judgment. The second defense is that
No, in a lorry, if somebody is
This is a commercial vehicle,
Cleaner,
premium is paid only to cover the risk of the driver only. They have
Other
collected
person.
50 rupees, not police. That's why the tribunal rightly rejected the claim of the.
my humble submission is that, my lord, in one of the judgment passed by this honorable court clearly held that the coolie is awarded, appointed for limited purpose, also to be treated as the employee under respondent number 1, because taking shelter under rule 100 of Karnataka motor vehicle rules.
no, first of all, they'll pay the compensation basing on the terms and conditions of the policy.
Please, my lord.
As per the policy conditions, only they have paid the premium for the driver.
No
None-
additional premium collected
none
for
else.
the loader and unloader.
Not
My-
only loader and unloader.
Coolie,
used to the-
Coolie.
Anybody,
Any-
they have not paid the. they have
Whoever
not
I may be. My lord, my humble submission that it is to avoid the wear and tear of the load and also to avoid the wear and tear of lorry. It is necessary.
Order be passed contrary to the terms of the.
In this regard, I am producing the
Consider after lunch. Pass over this part. Yes, next.
One submission. After lunch, Lokadala, so many cases are posted
Today,
today. That's not possible.
tomorrow,
tomorrow.
difficulty.
Tomorrow, okay, my lord.
Tomorrow, I have no problem.
Yes, tomorrow, next.
Cell number 26. HC Rishabhen Raya,
Paper.
Team Hadeva.
On what ground the insurance company is here?
On 3 grounds, my lord.
Hmm.
First ground is, my lord, deceased was a pensioner aged about 17 years, my lord. 70 years.
Hmm.
70 years, my lord.
Audition. No, liability, quantum.
Quantum liability, yes, both, my lord.
Quantum liability is what is the ground on liability?
Quantum, my lord, deceased was aged about 70 years.
Liability.
Liability, my lord. Liability because, my lord, liability passion on the insurance company.
Hmm.
In this case, my lord, the owner has appeared before the court.
Hmm.
In the trial court, my lord. Once he has appeared before the trial court and he has contested the matter, it is bounden duty to produce the driving license of the driver who was on the wheels at the time of accident.
He has not done.
Not done. That's the most important point, my lord.
What did the court say? Court has.
And also in this case, my lord. No.
trial court is not
Trial
ordered
court
to
has
pay and
partial
recovery.
the
my lord.
liability and
It's
the
fixed to liability to the insurance company.
insurance company.
Pay and-
My lord, I examined the investigating officer also. I produced the translation copy of the.
Charge sheet is filed.
Yes,
Whether the
sir.
charge sheet says that there is no, under the provisions of the Motor Vehicles
Yes,
Act
sir.
it is registered?
Yes, IO has been examined, my lord.
Not IO, charge sheet, what it says. Under which provisions the charge sheet is filed?
Charge sheet, my lord. Charge sheet, I'll come to them.
Look at, you have the copy of the charge sheet?
Yes, my lord.
Under which
My lord, in
provision?
the charge sheet, they have not stated that you do not have a driving license.
Then?
Second point, my lord. We have examined the investigating officer before the court.
Investigating officer cannot say something contrary to the charge sheet which he has filed.
My lord, when the investigation officer has been, when owner himself has appeared before the court.
Please tell, he has investigated, filed a charge sheet.
Yes.
The charge sheet isn't mentioned about it.
Yes, my
No,
lord.
can you say contrary to it? Can this court consider?
Well, it is a mistake on the part of the investigating officer.
Mistake before the court. Rightly filed before the charge sheet before the criminal court. So that is gone. What is the next one?
Well, my lord, because once owner has appeared before the court, it is a bounden duty of him to produce a driving license. The license is, he has got LMA. The vehicle, the unladen weight of the vehicle is
Yes,
more than
yes.
that.
Next, please come to the quantum. What is wrong with the quantum?
The quantum, my lord,
Page number 20, paragraph number 24,
Page number 9.
he was aged about 70 years, my lord.
70.
Yes.
Which year is the accident?
2021. man.
2021. What is the income?
My lord, he is working as a D group employee.
Huh?
D group employee, my lord.
D group.
Retired D group employee.
What is the pension is receiving?
Pension is 16,354 rupees.
Court has taken how much?
50% of the income.
50% of the.
And he is appointed for a temporary contract basis employee, my lord.
That
He
has
is
not
earning
been
rupees
proved.
12,650.
You know, this is not your appeal. How much the court has taken?
Court has taken as per the order by the income was
So what
taken
is
by
wrong
the
with
trial court.
that?
He is getting pension of rupees 16,354. My lord, court has taken 20,827.
50% of the income and
And second and third respondents are the majors. They are not entitled for compensation. Wife is only dependent. This court would have taken 50%, my lord, instead of 1/3.
That is one ground. Next,
Yes.
please come.
But the question is, my lord, in this case, when I have examined the police officer before the court, he has not cross-examined him.
Agreed with the award passed in MSC number 5693 of 2021 dated 7th August 2023, whereby the court had granted compensation of an amount of rupees 10,48,080 and the fixed liability on the insurance company. The insurance company is before this court. Learned counsel appearing for the insurance company submits that they have examined the investigating officer. The driver of the offending vehicle is not having a valid driving license. The owner of the vehicle having contested the matter, it is his duty to place before the court the driving license that he has not chosen to do. And as per the evidence of the investigating officer, he is not having a valid driving license. In those circumstances, insurance company is not liable to pay the compensation.
Section
It is
187,
submitted that-
134 and 304A, my lord.
What is that?
Charge sheet under section 188, 187, 134 and 304A, my lord.
The claimants are wife and the two and the two children. It is submitted that they are not they are not dependent on the father, hence they cannot be treated as LRs of they're treated as a dependents, and the court ought to have deducted 50%. It is submitted that both on the liability as well as on the quantum of compensation, the interference is required from this court. Next, land counsel appearing for the respondent submits that the
One more
charge
point.
sheet is not filed.
One more
There is
point, my lord. We have examined the officer of the company.
Not the investigating officer. Not investigating.
Investigating officer also we examined.
Submitted that they have also examined the officer of the company. Land counsel appearing for the respondent insurance company submits that the respondent claimant submits that the tribunal has rightly considered and rightly granted the compensation. It is submitted that the charge sheet is not filed
that the charge sheet does not disclose that the driver of the vehicle is not having a valid driving license. In that case, the evidence of the investigating officer cannot be considered when he has not filed the charge sheet. What is that?
The decision of Karnataka High Court. Justice Raman Reddy, because once
In his arguments, land counsel appearing for the insurance company had relied on the order passed by a coordinate bench of this court and Yashodhara B. Shetty versus United India Insurance Company Limited and other reported in ILR 2007, Karnataka 4567. Which paragraph?
para 20, my lord.
Paragraph number 20, extract 20 and 21. Basing on this, learned counsel that in the absence of the evidence to discharge the burden of proof of the insured, it cannot be said that the MLCT was fully justified in fastening the liability on the appellant owner and absolving the insurance company of its liability to pay the compensation. The next para, having heard the counsels on either side, peruse the material on record. First, coming to the aspect of liability, according to the insurance company,
para 24 of the judgment, my lord, because loss of love and affection has been awarded of rupees 75,000. He is not entitled. Because in para 24 of the judgment, my lord, of the lower court.
Yes, 24, loss of dependency,
Yes, my
then
lord.
loss of consortium.
Yes, my lord.
No, loss of consortium, there are how many? 4. 4 into 44, it comes to how much?
They have not filed any appeal, my lord.
No, no.
132,000.
I'm saying 4 into 44 comes to 176.
Yes.
So even this is calculated 120. I think then in that case we will interfere.
Yes, my lord. And
Only
also
on this count.
transportation
And
of
my
dead
lord,
body.
No, 1 minute. 176,000 plus 36,000. It comes to how much? 12, 11. 2,12,000 would be the amount. What is granted by the court? 1,20,000.
Plus 75.
75.
Plus 15.
15.
And 5.
5,000.
Only
3,000.
10,000.
3,000.
3,000. Very meager.
So shall we decide?
Not necessary.
What did you say? Liability. It is a case of the insurance company that there is no valid driving license to the driver of the offending vehicle, and the owner who has contested has not placed any document before the court with regard to the driving license.
Yes, madam. He has appeared. One has
I
appeared.
recorded that. I'm recording
Yes, my
that.
lord. It is a bounden duty of him to produce the driving license.
It is, according to the council, it's a duty of the owner to place the document, and he cannot be absolved from the liability.
Pay and recovery ಮಾಡಬಹುದು sir.
Judgment of this court.
This court can pay at least pay and recovery order may possible.
This court has, and he has relied on the judgment of the so and so referred supra. It is submitted that the investigation officer is examined. In this case, the investigating officer has done the investigation and also filed the charge sheet. As per the charge sheet, charge sheet does not disclose that the driver of the offending vehicle is not having a valid driving license. In that case, having filed the charge sheet, he cannot give evidence before the court contrary to the investigation made by him and the charge sheet filed by him. If it is a case of the insurance company that he is not having a valid driving license, the burden lies on them. The owner of the vehicle, what about notice to hear him in this case?
Yes, my lord. Notice has been issued. Owner has appeared. Owner has appeared, my lord.
It's not produced before this.
Owner himself is appeared before the court.
Asking what about notice before this court?
This court is placed expert, my lord. In the trial court, he has appeared.
You have filed a notice to R4 is held sufficient. Now you say that notice to him is not necessary here.
R4
Is held sufficient.
I filed a memo.
Huh?
Sorry, my lord. Then I will text.
Huh?
Text ups.
What steps? When the matter is listed for file hearing. He was set ex parte before the trial court.
Yes, my lord.
He's appeared before trial court.
Yes.
He's contested.
He has
So
appeared.
I'm asking, was he set ex parte?
Yes, my lord. Allah, he has appeared, my lord.
Appeared and contested.
So he contested.
Yes, my lord.
Then why you ask for dispensation of notice to him?
Paper publication.
Paper publication.
He's still.
Allah, I have taken paper publication, my lord.
Yes. What is that? They should have. Burden lies
I have
on
taken
them.
paper
Right,
publication.
burden lies on them. At the same time, the liability of the owner, the insured, it is a liability of the insured to place before the court to adduce evidence whether the license is there, whether to place a copy of the license. Having contested the matter, why he has not chosen to, the owner has not discharged his the obligation by placing the same. In this case also, the notice is served to the owner, but he has not turned up. In these circumstances, this court is of the view that the insurance company, the pay and recover will apply, and the insurance company shall pay the amount and record the same from the owner of the vehicle. Then when it comes to the compensation, this court has perused the order, and the compensation that is awarded by the court is as per law and based on the facts of the case. In those circumstances, this court do not find any reasons to interfere. Accordingly, the appeal of the insurance company is partly allowed, and the insurance company shall pay and record the same from the owner of the vehicle. The amount in deposit shall be forthwith asked to.
Let amount in transport to tribunal.
Huh? Amount
in
in
deposit
trial.
at transport. Madam.
Court officer? Court officer? ಕೋಟಲ್ ಹೌದು ಕೋಟಲ್ ನಂಬರ್ 10 ಕೋಟಲ್ ನಂಬರ್ 18 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 10.
ಹೇಳಿ ಸರ್ ಏನ್ ಬೇಕು ಹೇಳಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಏನಾಯ್ತು ಫಸ್ಟ್ ಲಿಸ್ಟ್?
10 ಅಲ್ಲಿ ಡಿಲೇ ಕಂಡೌನ್ ಆಗಿದೆ. ಗೆ ಅವರು ಸೆಂಟ್ ಟು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದು ಮೆಮೋ ಫಾರ್ ವಿಡ್ರಾಯಲ್ಗೆ.
ಓಕೆ ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
Continue the list. Yes, sir. Twenty-seven. A memo is filed stating that the main petition itself is filed, posted for judgment on 23/8/2025. Hence, the petitioner is not inclined to prosecute the matter, accordingly dismissed as withdrawn. Yes. Hmm. Hmm. A memo is filed seeking to withdraw, dismissed. Yes. Yes. Ready? Hmm. Where is the table? Table is not there? No? Where do you get that?
I have made a synopsis at page 1 of the.
Hmm. How many are the injuries? What are the injuries?
Right. Injury to right hip, then injury to right lower limb.
Where do you get this page number?
Page 25, one is page 25, internal page 14 of the.
Hmm.
The period with the doctor.
Right, if you swelling present. Where is the mention about the wound certificate? Right thigh, gluteal muscles and leg muscles present. Deformity at right region, shortening of the right lower limb and right lower limb drop present. So under the head of pain and suffering, we'll grant 40,000. Then medical expenses as it is.
Medical expenses, yes,
1,03,150. Then how many days was in hospital?
6 days, my less.
Rightly granted 7,000. Then loss of income, which year is the accident?
Loss of future income is not taken, madam.
No, loss of income during the later period.
15,000 has been granted.
Which year is the accident? 4/9/2020. 2020, it is how much? 23. What is the amount for 23?
My lord, accident has happened in 2021.
This MBC itself is of
23/3/21, my lord.
Yes, 15,000. 15,000 into 2, 30,000.
Please.
Then come to that the loss of future earning disability. Where do you get that?
loss of income. retired teacher, he was getting pension. My contention was he was owning agricultural lands, which could be the name of his mother, and he was his sole real member was supervising the agricultural property. The trial court,
Now, if that is the case, loss of income can't be 30, we will take only 15. You said in your loss of income during later period, the petitioner as per the available records could not do any work for 1 month. About 1 month after the accident, that is the evidence. So we'll grant 15,000. Then, where is the evidence to show that you are working?
Now we are seeing is a retired teacher. He had some agricultural lands. He was supervising the agricultural lands. My categorical evidence was earlier by way of the supervision, I used to get an income in excess because of this disability. Now he is not able to.
What is the age?
His age is 60 years.
65 years.
At the time of accident, he was about 60 years. He is having his farmland in Chennapatna. He stays in Nagaton. Every weekend he used to go there to supervise and add his neighbors. Now his supervision has completely come to nil. The tribunal, my lords, has taken 0 on the ground that agricultural income, even in spite of his lack of supervision, his income will not decrease or add by India agricultural land. But you are not even telling me.
What is the disability according to the doctor?
Whole body.
Disability is shortening, he is having shortening of leg and there is a fracture to his hip.
Allowed 50.
He cannot, earlier he was very.
But that's what is the evidence of the doctor?
55% to right lower limb, my lord. 18% to whole body, 55% to right lower limb.
We will, loss of amenities, sir, will grant the amount.
Because you are not also consider on this because you are not kindly see one in a case you are there.
Loss of amenities, court has granted 10,000. We grant 50,000.
Because even in a case, lords, where lords no evidence is produced, this now the time has come that these courts are taking the emotional income. Here is a case I produce that I am owning farmland. I give evidence that I have to supervise this farmland. Because of my lack of supervision, the agricultural income has drastically reduced. In spite of this, the tribunal feels to grant even a single paisa towards the loss of income. And now I need an attender also, my lord, to do my day-to-day activities. And what happened, my lords? During the pendency of the case before the tribunal, I sought for re-examination of the case. On the ground that a question was posed by the government council of the insurance, saying that what has happened after the accident, whether your agricultural income has become nil. I said no, it has not become nil. But the clarification was required to say that it has not become nil, but it was reduced. Therefore, I filed an application for re-examination. That was not allowed by the tribunal. I had to approach dishonorable court by filing the petition. This petition, in the petition, dishonorable court permitted to carry on with the re-examination. But the tribunal being prejudiced that I approached dishonorable court has taken 0 income towards the agriculture. So what you plainly see, I have produced 13 RTC extracts. These are the agricultural lands which have been owned by me. Now there is complete, now this petitioner appellate alone was supervising. He is having his there are no other male members, old age mother. All now because of lack of supervision, his income has drastically.
How the supervisory income has to be assessed? That cannot be, because supervisory income, it can't be assessed.
Any labor, even today, emotional income for a minimum wage, if I have to keep one labor to supervise, the same income.
That equally amounts to granting loss of for the loss of future income as per the chart.
That has to be granted. That is what, even in a case, assuming my lords, I have not produced any evidence. Still, this honorable court would take future income based on the notional income.
But not for the supervisory income.
Notional income. I am having agriculture land. You are lodging a technique, imagine a scenario. Okay, I am having agriculture land.
You tell the court how to calculate. It can't be calculated on the notional income.
Because I had claimed that out of this agricultural income, earlier I was fetching a amount of rupees 5 lakhs per annum. Now that has been reduced to 1.5 lakhs per annum. That was the specific evidence given before the tribunal. My humble request before your lordship is, at least the notional income ought to have been considered for the supervisory charges of, and also the tribunal has failed to consider that the applicant is in need of an attender to take care of his day-to-day activities.
Some attender has to take care of his daily activities.
His daily activities.
That's what, where is the doctor said? Where is the evidence of the doctor?
My lord, in fact, produced RTCs are not in his name, my lord. Then they not produce any supportive documents to
Come.
kindly see.
Passed in MVC number 969 of 2022, dated 4 September 2023.
Your Honor, can we consider granting some income towards this supervision?
I'll consider that. The where the court had granted an amount of rupees 1,60,150. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 40 lakhs for the injuries sustained by the claimant. Because of the injuries sustained in the accident, there is a shortening of he is retired, age 65 years as on the date of the accident, and according to the claimant is having agricultural lands, is supervising the same and getting an income of rupees 5 lakhs per annum, and now it has come down to 1.5 lakh. The tribunal had granted the compensation as per the table given below. It is at page number 1, the table is extracted. As per the table given below, the tribunal has granted the compensation, and counsel submits that when the claimant has sustained the injuries and there is also shortening of the leg, under the head of pain and suffering, only 25,000 is awarded. It is submitted that for the disability of 18% to the limb,
Please.
to the whole body.
18% of whole body,
18%
55.
to the whole body.
18.39% to the
Whole body.
55.17% to the right lower limb.
Body. The court had not taken. The court. The court had. What is that? Before that. The court, under the head of loss of amenities, only an amount of rupees 10,000 is considered. What is the evidence of the doctor with regard to future medical expenses? Any operation is required?
No, no, my lord.
Your Lordship, may take up to page 26.
What did he say?
It is true that the factors are related and implants are in same group. The petitioner is okay. The implants are in site. They have to be removed in future.
My lord, fractures are united and implants are in situ, my lord.
Huh?
Fractures are united and implants are in situ. In page number 15 of judgment, my lord.
They don't have to be removed.
Implants are there in the body, but have to be removed.
Come. The future medical expenses also, no amount is awarded by the tribunal. It is submitted that on all, and the court has not granted any amount on the head of future loss of income. It is submitted that on all the counts, the amount has to be enhanced. Next para. Then counsel appearing with respondent insurance company submits that the court, basing on the evidence, had rightly granted the compensation and no enhancement is required. Next para. The claim, considering the grievous injuries sustained by the claimant at the head of pain and suffering, this court is granting 40,000 towards medical expenses. Court has already granted a reasonable amount basing on evidence and no interference is called for. He was there in the hospital for 7 days and the head of conveyance, food and nourishment, 7,000 is granted. Coming to the loss of income during the later period, as this accident has happened in the year 2021, considering the notional income is 15,000. 2020?
21.
15,000, as it is stated that he was sitting idle for a month this court is granting 15,000. Coming to the loss of amenities, considering the disability of 18% to the whole body, this court is granting an amount of rupees 50,000. The 50,000. As far as the future loss of income is concerned, with the disability of 18%.
Tribunal take on 15%. Tribunal considered 15%.
Because it has not granted any amount, where is the consideration?
Tribunal, though doctor says 18%, it says I will take it as 15%.
But for what purpose?
For the attendance, during the later period.
Considering the fact that he has sustained 18% disability and there is a shortening of leg, even otherwise also, and also considering the fact that he is doing agriculture, so and supervisory income he has lost, this court is inclined to grant a lump sum amount of 50,000 in that regard. Altogether, the claimant is entitled for an amount of rupees 3,05,150. Accordingly, appeal of the claimant is partly allowed, enhancing the compensation from 1,60,150 to 3,05,150. Yes, next.
Number 2.
Yes.
I appear for the respondent.
Huh? Switch on the mic.
Sorry, ma'am. Yes, husband's take-home salary is 38,000 rupees.
13 or 30?
38. 38, my lord. Page number 49 is the.
Is granted?
20,000 per month, my lord.
What do you say?
My lord,
Your lordship suggested on the last occasion 12,500.
Yes.
That can be done, my lords, with expedited hearing.
Lordship, before that, I have one submission, madam. She has admitted that marriage is not consummated, madam. They have stayed together only for 15 days, madam. She has completed MSc.
Lord, he
she has
files a
submitted
petition for divorce.
Postgraduate.
Within 2 months, saying that there is aversion from the side of
I
the
have filed for
wife. That too within
As
2
far as
months.
consummation of marriage and other things are concerned, in an IA, we will not decide all that. Now, what is a reasonable amount? 12,500. What is that? That's why it is adjourned today.
Yes, madam. It was adjourned, directing him to see why, despite she is a qualified woman, not chosen for
Lord,
working.
she has done MSc, my lord, in physics, but she hails from a rural background. And my lord, she married at the age of 32. She was not employed earlier.
When is the marriage?
Marriage, my lord, is on 27/1/22.
From when they are separated?
My lord, they separated in 14/2/22.
Then what is the effect of this marriage on her,
My lord,
on her education, on her?
Yes, that is why I am submitting, my lord. She was not employed even earlier also. Now, what I am given to understand, my lord, is that she hails from a rural background, and my lord, her ability to, my lord, to get a job is quite
She will
limited, my
definitely
lord.
get some job. May not be befitting her educational qualifications.
Yes.
She'll get some job. She has to.
So she has made her. This is my instruction. She has made her efforts, my lord. But they are staying in a remote village along with her parents, and she is
Where
also,
she stays?
my lord, in a village called as Kavu, my lord, near Puttur. That's a small village. From Mangalore, my lord, it's about 80 kilometers.
No, my
Mangalore
lord.
is the
It's
main city.
55 kilometers, man.
55 kilometers is Puttur, my lord. Again, another 15 kilometers from
Ishwar
there.
Mangala
Because
to
we both are from that place only, so we know.
Ishwar
It's
Mangala
about
to
65 to 70 kilometers from Mangalore. So she is also, my lord, cannot afford an independent house in Mangalore to get a job because, my lord, her qualification is MSc in tissue culture. To get a, my lord, befitting job also, to go and stay there independently.
Please come. Agreed with orders passed in I number 3 in MC number 149 of 2022. Which court is this? Family Court, Mangalore, 2022, whereby the court had granted 20,000 per month to the wife. The husband is before this court.
Then counsel appearing for the husband submits that the salary of the husband is 38,000, wife is educated, and still she is not working. When the husband's salary itself is 38,000, the court ought not to have granted 12,000 as maintenance. It is further submitted that the wife is educated, and in spite of that, she is not working. Even on that count also, she is not entitled for maintenance. Next parallel, and counsel appearing for the respondent submits that though the wife is educated, she is residing in a remote village along with the parents. Because of her rural background, she is not in a position to secure the job. It is submitted that she is making all her best efforts. Next para, having heard the counsels on each side, there is a material on record. The family court had granted 20,000 per month as maintenance. When the salary of the husband itself is 38,000, on the first count, the court ought not to have granted an amount of rupees 20,000 as maintenance. The wife being an educated lady, she should make all the best efforts that she secures a job, and forever she cannot depend upon the husband. That too, considering the fact that the marriage lost, it is only they were in relation, she left the matrimonial home within a month from the date of the marriage. She should have made all the efforts. Considering all this, this court is passing the following order. The order passed in I number 3 in MC number 149 of 2022 dated so and so 25/1/2020 25/1/2023 2023 is modified, and the amount of maintenance is reduced from 20,000 to 12,500. The next part. This is an MC of 2022. Already the family courts at Mangalore are disposing the matters of 2022. The same shall be disposed of by December 15th. Accordingly, that petition is disposed of. Next.
Much.
Okay.
Here for the petition.
Yes.
Ship, I need some more time for translation. I already given for translation, but
What translation? What translation?
that impugned order itself is in Kannada.
I think this order is passed. MC is of which year? 2018. Not necessary that we should interfere with this
My
order
lord,
now.
what happens is a foo farmer. She is parallelly preferred the criminal miscellaneous also for maintenance. So they are suppressed the filing of this and obtain a interim maintenance here.
Now,
That-
right from 2023, this matter is pending.
Yes.
There is no interim order. In that case, what is the purpose of keeping this matter?
There she filed the execution and recovered some amount.
So what I do is, I'll direct the court to dispose of the MC itself. Main MC itself. This is a raising out of MC.
Because there is a two maintenance for the same cause, same reason.
What I'm saying, anyhow, you don't have an interim order in this. That's what I'm saying.
That is
MC is
there.
fine. MC is of the year 2018. The impugned order that is passed by the court is dated 2/8/2023. Which court is this? The matter is pending before the senior civil judge and JMFC at Tiptur. No interim order is granted by this court. This is a raising out of an IA. At this point of time, this court is not inclined to go into the merits of the matter. As MC is 2018. Without expressing anything on the merits of the matter, this writ petition is disposed of, directing the family court to dispose of MC, not family court, the senior civil judge and JMFC at Tiptur to dispose of MC number 2 of 2018 by December 15th. Yes, next.
My lord, I appear for petitioner.
What is this dismissal of?
Lord, we have
WP?
not filed any memo, my lord.
No, it is not for dismissal. My lord, we have produced some school certificate, fee receipt. I think that may be considered.
No, why is it, why the cause title is showing that memo for dismissal
It is not for dismissal. My lord.
of WP by advocate for petitioner?
We have produced only schools are school expenses bills we have
Therefore, the
produced.
respondent prays to dismiss the writ petition for non-payment of intermenace. What is the writ petition?
Lord, writ petition, my lord, is
Where is the impugned order?
page 29.
29, operative portion.
5,000 to whom? To the wife,
Daughter,
to
alleged.
the daughter. What is wrong with this order?
My lord, in fact, we have denied the relationship.
Yes.
My lord, and we have come on record recently, my lord, with respect to that we have to take some instructions. It has come on memo. It should be taken up next week, my lord, we'll argue the matter. In fact, my lords may take the last order, my lord. And the last order we came on record, my lord.
So that's why this date is given. You asked for this date.
No, my lord, I have not asked. We have not asked for this date.
But then, why is it listed today? If it is listed, you have to
My
argue.
lord, regarding that memo, it was listed, my lord. With respect-
Finally, a week's time is granted, so and so. Let's forget about his thing. We will see on the merits of it. In this, no instructions are required. We can only look at the impugned order. It is an writ petition arising out of the IA. Please look at the IA. We'll dispose it off. We can't list the matters every day. Please provide.
Taken up next week, my lord. We'll argue the matter. One date. There's no instructions. We come on record.
Don't
recently.
ask. It is. List this matter as part heard on Tuesday. Yes, next matter.
Please. Great.
My lordship, kindly dismiss the petition. They have not complied any office objection, neither they have served any writ petition copy to me. And for settlement also, they have not appeared before the trial court.
1 minute. Whether the office objections are complied or not.
No, my lord.
This court on 23/7/2020, on 21/6/2024, has granted a week's time to comply with the office objections, or else the writ petitions shall stand dismissed without further reference to the court. Then what is the necessity to pass this order if they are keeping every matter again? As the office objections are not complied with, the writ petition is dismissed. Yes, next.
Case appearing by the petitioner.
Non-compliance of office
Yes,
objections.
my lord. In that some clarification has to given to my lord. The petitioner has filed the petition against the respondent, against his husband under section 125 of the CRPC for monthly maintenance. That has to be kindly see annexure A, my lord. Annexure A, cost risk kindly see, my lord. Gaurama, wife of Govindappa, aged 45 years, residing at so and so. Respondent, Govindappa, son of Puniyappa, age 45 so and so. She in that has filed the 125 the CRPC, my lord. In that kindly see, my lord, annexure B, my lord. In that annexure B, we the respondent in this matter.
Please refer to the page
yes,
numbers.
We the respondent number 2 in this matter.
Page number 22.
Page number 22, my lord. In this, kindly see the cost item, my lord. Gaurama and Govindappa. In that compromise petition,
Page number 23.
page number 23, para number 5, it is agreed that the parties between, after dismissals of the respondent and petitioner, Sarasama, my lordship, she is not a legally wedded wife. She is the husband of Annexure D and D, Yellappa and Anjanappa. She made illegal affairs with the Govindappa, then she threatening in the petition and compare by the claiming in this matter. Kindly see annexure D and E, my lord. E.
Page number.
Page number 32, my lord.
Sale deed.
See, this is the sale deed, serial number 3.
Sarsama Kom Yellappa.
Yellappa.
The respondent.
So the respondent who is in this petition is the husband of Yellappa. Kindly see another annexure E. ration card.
First of all, where is impugned
Yeah,
order?
in this ration card,
Where is the
see
impugned order?
Sarasama photograph,
See, annexure C,
annexure C, madam.
Page number.
page number
Page number
30.
30, my lord.
What is the order at page number 30?
Yeah, in this petition respondent present, the counsel for the petitioner respondent present, the petitioner respondent has compromised the dispute between themselves, the petitioner recovery of arrears of maintenance. Both the parties are compromised under section 23(3). Inquiry, the petitioner respondent stated they have entered into
Correct.
compromise
This is,
as per the advice.
as per the compromise, this order is
Yeah,
passed.
in that order, my lord, challenging under order 22 rule 3A, my lord.
You are challenging.
Yeah, it is, that is an IA, my lord.
Sarasama is not a wife.
Lasama is not your wife. Because of husband is alive. Annexure D and E clearly established that she is the wife of the, so Yellappa and Annappa. She is not your wife of
I am not able to understand, not even one thing. What is that you want to tell the court? Now, this is a impugned order dated when 27/6/2018. That is basing on a compromise memo, this order is passed. Now you are questioning this order before this court.
My lord, now what happened, he is passed away. That petitioner's husband is passed away. Entire the claim is pending before the court. He is an employee of KEB.
Issue a writ quashing the order dated 7/6/2018 in CMC number 138 of 2017 on the file of the so-and-so. Reservation of 50% in favor of the respondent to meet the ends of justice. You are questioning a compromise decree.
Yes, my lord.
Before this court.
Yes,
Can you
yes,
question
yes,
it?
please, my lord.
Can you question it in a writ petition before this court? What is the remedy available to the party?
Because of the compromise petition is itself not a survey, my lord. Because of that is an illegal. She is not your wedded wife.
Who will decide? Who will decide whether the compromise decree is right, wrong, fraud?
So in that is mentioned, second respondent is Sarasama, it is illegal. She has to establish the wife of their
Please come.
husband. There
The
is no
present
proof
writ
of
petition is
document.
filed seeking the following relief. The writ petition is filed by writ petition is filed against one Sarasama, and the compromise that is entered is between one Gauramma and one Govindappa. When this Sarasama is made as a respondent, office has raised an objection. Learned counsel for the petitioner submits that in the compromise petition, it is agreed between the parties that after the demise of respondent, that is Govindappa, the Gauramma and Sarasama, within brackets, second wife of Govindappa, have each entitled for 50% from the pension amount. That compromise decree which is entered, where Gauramma is also a party to the said compromise. Now the same is questioned, and basing on the compromise entered between the parties, a compromise decree is passed on 17/6/2018. Now the petitioner wants that particular clause in the compromise petition to be set aside. And according to the petitioner, Sarasama has nothing to do with Govindappa. Is it the case?
Yes.
Sarasama has nothing to do with Govindappa. Hence, the present writ petition is filed. The present writ petition is not maintainable
as a party to the compromise cannot question the compromise decree by filing a writ petition. Secondly, again is Sarasamma, who is not a party to the compromise decree, she cannot be impleaded in this writ petition and they cannot file a writ petition before the court. If any fraud is played and any decree is obtained, that can be questioned before the very same court, but not before this court. Even on that count also, the writ petition is not maintainable before this court. And the office objection with regard to the array of the parties is also a valid objection. On all the counts, the writ petition is dismissed, giving liberty to the petitioner to avail the appropriate remedy subject to the law of limitation. Yes.
I appear for 50. The matter is settled.
Settled.
Settled for 7,25,000.
It is
Now I
settled.
have to pay 3,25,000 DD. I am giving it to the respondent.
And the remaining amount?
At the time of the divorce petition.
There.
In the
I'll just record that the parties have entered into a compromise, and as per they have agreed for a full and final settlement of an amount of rupees
25,000.
7,25,000 today before this court.
3,25,000.
An amount of DD for an amount of rupees
25,000.
3,25,000 is handed over to the council for the respondent. The remaining amount will be paid once the divorce proceedings comes to an end. Once they file an appropriate, they will file a joint memo before the family court, and there they will pay the amount. In the light of the same, no further orders required to be passed in this petition. Accordingly dismissed. Yes.
Much.
Next. What is this council submission?
We have in fact complied with all the office objections. I was pleasantly surprised in the morning when I saw this.
Appearing for respondent, my lords, seeks time to file objections.
Copy of IA2, IA3 and objection to both the IAs and objections to main petition to be filed is the office note. Council submission. For the above objection, the council for the petitioner submits that we will submit before the court.
No, my lord, it's on record. It's on record. My
Oh,
apology.
where is please show where is the copy of IA number 2?
My apologies. My humble apologies.
It's just wasting court's time, Mr. Counsel. Please understand. For everything, and why are they posting before the court? Section people are also not exercising. When something has to be filed, it has to be filed. Office objection shall be complied within a week. Default order. Yes. How many times the time will be granted? Already there is a default order. I will dismiss it.
Because regular council having engagement today. Regular council is not there.
So what we can do, a week's time is granted to do the needful. By the time if the needful is not done, petition shall stand dismissed. This court on 21/7/2025 has passed an order. If the needful is not done, the petition shall stand dismissed without further reference to the court. Even till now, the office objections are not complied with. This is a writ petition of the year 2020.
2 days maybe.
No,
Because
2024.
regular council has engagement
2020.
today.
What happened?
Engagement today, regular council. That's why, my lord.
That can't be a reason. Engagement,
please.
clerk will do it, not the council will do. List this by Tuesday. If the needful is not done, the petition shall stand dismissed. And in spite of already an order passed, it is submitted that some inconvenience to the council, it will not be considered and the writ petition will be dismissed.
God bless.
Next. What happened to 9?
Petitioner.
Yes. 10.
Appearing for the petitioner list. I have already paid the process on dated 30/7/2025, Your Lordship, but there is a delay of 5 days. Kindly accept that.
What accept? Will not accept.
Oh, every matter, I understand that. Every matter can't come two times, three times to the court. When I say it is 1 week, 1 week,
Yes, Lordship.
I'm not.
Humble request.
The,
Lordship, kindly humble request.
what?
There is an inconvenience.
Then, when the court has directed the council to comply with the office objections within 1 week, to do the needful within 1 week, this court has already passed an order that if it is not paid, the petition shall be dismissed without further reference to the court. The council submits that 5 days after the 1 week time is over, they have complied with the order. And as such, the said order may be recalled without any petition. No, why they are posting it before the court? Now it is by way of this order, it is dismissed. If they want, they have to file an IA to recall the order.
I instructed now also, I called them, I told them, without further reference to the bench, you have to seek it out. They are telling that partial compliance is there, then bench they are posting. Because he paid after last.
18/7/2025, already there is an order is passed. As such, the writ petition is dismissed. If the petitioner wants, he can, it is for the petitioner to come up with an appropriate application. Yes, next. It is dismissed. Yes. Same, 10 also same. Yes. Same order.
My lord, I'm appearing for the petition in this case. I have complied the office objections. So in accordance with the writ proceeding rule 6A, so the alphabet O is what not supposed to be used is their contention. My contention was O is not mentioned in accordance with 6 rule A of writ proceeding rules. So my lord, may I proceed with
The following objections said to be complied. WP to be stitched as
yes, my lord.
readable.
It's readable, my lord.
Need copy of page 10 to be filed.
My lord, my humble submission, page 10, what happened here was they asking me to type, so for which the words may increase and the pagination will also be in accordance to that. So it create chaos, my lord. So my humble submission.
So don't file that paper, remove that copy itself.
My lord, my lord, the office of the court insisted me.
The problem is there are certain clerical works. Certain work, the work that has to be dealt by the court is not the clerical job. When they tell you there is a procedure, when they tell you to do something,
I would like to satisfy this honorable court by reading the writ proceeding rules where the honorable high court or registrar has given the circular where it says that it can be legibly written, so or typed. So I have written, my lord. Kindly peruse that. My lord, this matter is very urgent at this point of time. I request you.
Urgent, subject to other things also. Where is it? Let me see. Need copy of page 10. Where is it?
Page 10, yes. A copy of the writ, the copy of the petition and objections has to be filed. The annexures has been marked accordance to that.
Need copy of page 10 to be filed. Where is it? I'm asking. Where is page 10? You write something like this. That's what they're saying.
Yes, my lord. Because that was not done in the beginning. The office of the court insisted me to file the petition copy of the trial court, for which that was not required in accordance with the writ proceeding rules. Because I am challenging only on the impugned order.
If you impugned order, there would be an IA. There would be objections to the IA.
Yes, ma'am. Yes, my lord.
That they are not required as per the writ rules.
No, they required, but they are requiring the main petition copy from the trial court and the objections, which is not even in the part of the merits. My merits is entirely different from the main petition copy, so that is not required, my lord. So for which they have insisted me.
What he is saying, both are not able to understand.
In between the type of format, he has written somewhere in maths. Because it is a copy, here all is the format.
Where is the order impugned?
The impugned order is annexed Q, my lord.
Page number?
518. My lord, may I, with the permission of this honorable court, may I proceed, my lord?
Where is the IA in support of this and where are the objections?
Okay, I would like to help you. A copy of the objections, 29 page number.
29.
29. And the copy of the interlocutory application is 26, my lord.
Why these much, all these papers are required?
I beg your pardon, my lord.
All these papers are
Yes,
required
yes,
for
my
an
lord.
interlocutory
Yes,
application.
yes, my lord.
So please
It
come to
is-
the impugned order.
Okay. My lord, in the impugned order, my first prayer in this case, the impugned order itself is capricious and erroneous in its nature. The Supreme Court, in accordance with the
Please come
Arnish,
to the facts of the case. What is your salary?
my salary is 1,29,000, my lord.
Yes. What is the wife's salary?
My wife's salary, she is earning, but she has not disclosed in
As per the
accordance.
record, she is not earning.
No, she is earning. She has various source of income, my lord.
Did she say so?
Yes, my lord.
That she is earning?
No, she said she is not earning.
Yes. According to you, she is earning.
Yes, my lord.
So there is evidence that you are earning 1,29,000.
Yes, yes, my lord.
Court
I'm-
has granted 50,000.
Yes, my lord.
Why she is not entitled for maintenance? Number one.
I would like to help you, my lord. Why she's not entitled for maintenance? Because she is having various source of income. She has a piece of land, whereas I am having only one source of income, that is my salary.
What is the evidence on record in that regard?
Okay, I would like to help you. That she has various source of income. Okay.
Was it placed before the trial court?
Yes, yes, my lord. It was traced.
Is it?
It was placed. My lord, kindly look into the page number 229, where she has a FIRE's account. Okay. And
229.
229. And and 259, my lord.